The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right. Good morning. Mr. Bacharach, are you ready?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the court. My name is Al Bacharach. I represent the appellant, Bryce Johnston. In order to resolve the underlying litigation in the lumber liquidator matter, class counsel and the defendant entered into a settlement agreement. The settlement agreement provides for a attorney's fee maximum of 1/3 of the value of the settlement. Class counsel could have contracted for a sum certain, such as $11,000, but they did not. They went with a percentage. In the previous appeal, this court found that the settlement agreement was fair, adequate, and reasonable. The court also found that despite the wording of the settlement agreement, that the store vouchers provided by the settlement were coupons under the Class Action Fairness Act. Because the store vouchers were coupons, they could not be used as a number that the district court could then take a percentage of in setting an attorney's fee. So the settlement, which includes $22 million in cash and $14 million in coupons, turned out to be worth $22 million because under the Class Action Fairness Act, the coupons have no value until they're redeemed. The reason for that is because a percentage of the coupons will probably not be redeemed. And in fact, a high redemption rate in this matter would be 10%, which would mean that the 14 million turned into 1.4 million. So you can't do a percentage based on the coupon's face value. You have to wait for there to be a redemption. When this court entered the original order, it also approved the settlement contract per se as fair, adequate, and reasonable. The only point to the remand was to recalculate the proper amount of attorney's fees. In calculating the attorney's fees after remand, the district court noted that there was a problem because the settlement agreement itself and the notice to the class both limit the attorney's fees to a 1/3 percentage of the value of the settlement. That 1/3 had dropped from 1/3 of $36 million, the two parts of coupons plus cash, to the 1/3 of the cash value, which turned out to be about $7.
Can I ask you, it strikes me that your entire argument is based on an apples and oranges comparison, in that the district court has to do two things. It has to decide if the fee award is reasonable under CAFA, and it has to decide whether it complies with the contract. And those are separate questions. I agree that in deciding whether it's reasonable under CAFA, this court's opinions previously said that if you're going to calculate it based on a percentage, you have to ignore the coupons or unless the redeemed value. But that doesn't determine what the purpose is for purposes of the contract. And here the contract specifically defines the coupon value as part of the value for purposes of the 33% cap. So I guess I just want to give you a chance to address my conception. I think your entire argument is confusing two different questions, whether it's reasonable under CAFA and whether it complies with the contract.
Respectfully, I don't believe I'm confusing the two. The issue under CAFA would be an issue of first impression in this circuit with regard to subsection B, the court's ability to award fees based on a lodestar. But awarding fees based on a lodestar doesn't get you past the contractual limitation of the settlement agreement. The contract says it's to be interpreted pursuant to the laws of the state of Virginia. In Virginia, the Supreme Court recognizes that settlement agreements are contracts and that the terms of the contract control what the parties bargain for. In this matter, the parties bargained for an attorney's fee of 1/3 of the value. So the current value is $22 million.
But then what do you do about the fact that the contract defines the value as 22 plus 14? The contract tells us what the denominator is. The contract says for purposes of the contract, the denominator is 36.
Well, Your Honor, the contract provides for severability. It specifically says that the terms of the contract can, if any one of them is found to be invalid, that the contract is interpreted around the invalid term. So for the district court to be correct in awarding a fee of 45.8% in this matter, this court would have to find that the severability subsection of the contract is invalid. That's not correct under Virginia law. So we would look at the contract, we would sever that portion of the contract that says that the coupons are worth $14 million. You don't have to do anything besides sever that out. That leaves you with an agreement that the attorney's fees will max out at 1/3 of the value of the settlement, which is the $22 million figure. It is the amount that the class was noticed in terms of due process would be the maximum attorney's fee in this matter. So it can't not limit the attorney's fees simply because class counsel made a mistake with regard to how they wrote up the contract. I mean, the contract should be interpreted against the person that's drafting it, not against the class members who are paying $4 million. May I finish the answer?
Yes, you may.
Not against the class members who end up paying an additional $4 million in fees to class counsel. Thank you.
Mr. Clore?
Good morning, Your Honors. Robert Clore for Appellant Diana Cantu Guerrero. This is the second time we're before the court on this $10 million fee. The first time the court vacated based on the district court's failure to apply CAPA. This time, the district court misapplied CAPA by indulging the full $14 million face value of the coupons while ignoring the redemption rates. This court, in its prior opinion, recognized a circuit split between the 7th and the 9th Circuit regarding whether the lodestar method is allowed at all for coupon relief, for awarding fees from coupons. But what there's not a circuit split on is the discrete issue that Cantu Guerrero has focused on, and that is when you're engaging in the lodestar analysis and you're awarding fees and you're including coupons, can you consider the coupons without looking at the redemption rates and while assuming full face value? So every court of appeals that has addressed that specific issue has held that's you cannot do that under CAPA because it defeats the purpose, one of the underlying objectives of CAPA, which is to discourage attorneys from upping settlement value with coupons so that they can take the lion's share of the cash, which is exactly what happened in this case. And class counsel argue that the court wasn't attributing value, but if you look at page 5, page 5 of the Westlaw site, it clearly did. It did place value on the coupons, and it contrasted the cash awards, which provide a relatively small percentage of reimbursement with the voucher awards, which the court said, quote, subsidize a significant portion of the replacement costs. And then additionally, in the background section and elsewhere, the court referenced the vouchers at their full face value and never looked behind to see the redemption rates. I think the Sixth Circuit opinion in Lemon versus Vitamix, which is a 2020 opinion, is most instructive. There,
Wait, counsel, you've mentioned a couple of things that the district court says, but you left out a rather significant thing the district court said, and I'd like to get your response. I mean, the court said it was awarding fees. This is at Supplemental Appendix 1109. The district court says, quote, without attributing any value, face value, or redemption value to the coupon portion of the settlement. That is an express statement by the district court. What do you do with that?
The problem with that is that's at the front of the opinion, and then the actual analysis where the court considers how what the settlement is worth. So the lodestar analysis is you look at the hours, you look at the rates, and then you can adjust it based on the degree of success, which is this third step. And that third step, the court repeatedly discusses the value of the vouchers as if it's just 14 million, and says, look, the cash, recognizing the cash is going to only reimburse class members for 5%, but the vouchers are much more significant reimbursement. And so you can say that. I mean, that's all that is words at the outset, but the analysis demonstrates that the court did actually consider their value and did not look behind their face value to consider the redemption rates. And that's
Mr. Clark, if the court is looking at a degree of success, are you saying that the vouchers don't factor in that calculus?
I'm saying
for the purposes of determining degree of success, forget about value in that sense. Are you saying that the court can't consider the vouchers as to the degree of success?
Oh, no, Your Honor, the court can consider the vouchers and the degree of success, but it can't consider the face value without looking behind and seeing what are the redemption rates. And that's...
But no, what it did, the first steps of the lodestar determined, how much time was spent, and that was found to be reasonable. Then at what rate was the time billed? That was reasonable. The second step, what would be minus? Well, I already got some confusion here. They said it was all completely successful. So the minus figure could have been zero, but forget about that. Whatever it is, now, having found the work spent was proper, the time, and the rate at which it was charged is proper. Now let's see what the success is. And given no value to the coupons at the earlier part, but you say, but that is successful, no matter whether, for example, if I give you a check for $10,000 but you never cash it, it's still success. When the lawyer said, oh, I don't get my fee because my client decides not to cash my $10,000 check. Why? How do you dismiss that from the degree of success, the coupons?
I'm not asking for the court to dismiss it from the degree of success, but in your example, we're not talking about a $10,000 check. We're talking about coupons that have ostensibly some value, but they presented no evidence of what that value is, and that's.
But aren't these people who decided they wanted the coupons, and those who didn't want it, that was the cash part? Am I correct?
You are correct that those 20,000 or so folks who selected.
Well, don't you think that would don't you think that has an influence of what the normal redemption rate is, which is, I think your colleague said 10% or so. Here, where they elected, having had an opportunity to get the cash, they said, no, we want the coupon. Wouldn't that change the calculus even that? Here.
So these are all good questions, and they could have been answered.
Thank you. I appreciate that. Go ahead.
They should have been answered by class counsel. 28 USC 1712D provided them an opportunity to present expert testimony on what the likely redemption rates are. There's, in this case, I believe there'll be even 10%. Most rates are actually closer to 5% or based on studies that we cited in our brief.
Mr. Clark, can I ask you one question in your remaining time? Do I understand you to have said earlier that you are not urging us to adopt the Ninth Circuit's outlier view that the district court could not apply the lodestar in this case?
So we didn't take a position on that because, the district court went with the Seventh Circuit's position that you can. And, our position, our point is that regardless of what method you use, if you're going to consider vouchers, you don't get to pretend they're worth the face value that everyone knows they're not. Thank you.
All right. Did you have any conclusion? We did pepper you quite a bit. I know you divided your time, and something else you want to take a minute to wrap up? I just want to be.
Sure. Well, I wanted to get more into the Linneman case. I'm happy to answer questions about that opinion, but otherwise, I just point out that what we're requesting from the court is, granted, a little bit unusual, asking for the court to enter a fee rather than remand again. And the reason we're doing so is, number one, judicial economy, and number two, this would be a third bite at the apple. Class counsel had the opportunity. We urged them below repeatedly to present expert testimony so the court would be armed with the appropriate information to make an informed decision on what the vouchers are worth. And so that's why we're asking the court to enter a fee, recognize that as it stands, there's no evidence on the value of the vouchers. So to recognize the diminished value of the settlement and to adjust the multiplier accordingly. And then alternatively, we're asking for a remand with instructions that the courts consider the redemption rates and make an adjustment based on the diminished value. Thank you, Your Honors.
Thank you, Mr. Clore. Mr. Toll?
Thank you. Good morning. May it please the court, Stephen Toll for the plaintiffs' appellees. Your Honors, before I get into the legal questions, I want to give some background, factual perspective that has to be taken into account, plus the purposes of CAFA's fee provisions. I've been personally involved in this case since 2015. This was a very complicated case. You've read probably Judge Trenga's long opinion on the motion to dismiss in late 2015 and his 40-page summary judgment ruling. There were 12 different claims brought. This was very hotly contested. We ended up, after we had no luck in mediation with an outside mediator trying to get more than $5 million, he asked Judge Brinkema to get involved, and she was terrific in getting this case settled. We were pushing for a lot of cash. She helped us get the maximum possible. Lumber Liquidators was struggling financially, and we got $22 million in cash, but we felt it wasn't enough. And we worked with the judge and defense counsel to get more value for the class members, and it came up with $14 million in coupons, which I'll get into a little later, are very valuable to those who want them. And as you note in the record, there are 23,000 people who want the vouchers. And as Your Honor indicated, why select vouchers unless you want to probably use them? I can't guarantee 100% of the 23,000 will use them, but we think it's going to be a high likelihood. And there's a 3-year expiration period. We've only been through 1 year so far, and there are 7 states, including 2 of the largest states where they sold this product, that have no expiration date. So to follow out redemption forever, it could take many, many years. But what's the purpose of CAFA's fee provisions? The purpose is to stop abuses by plaintiffs' counsel in getting windfalls by getting valueless coupons in a settlement. That is not this case. And let me explain a little bit more about that. Number one, the cases both sides cited, to Your Honors, on the coupon issue under CAFA. Just look at each one of them. Look at the inkjet case, which is the kind of outlier in the Ninth Circuit, only a 2-to-1 and a very strong dissent. The coupons there were $2 to $6. The Radio Shack case in the Seventh Circuit, you were dealing with $10 coupons, and they expired in 6 months. The Southwest Airlines case in the Seventh Circuit, also what the coupons were, free alcoholic drinks, 1 drink. The Galloway opinion in the Eighth Circuit, a $10 off car rental. And then the Linneman case in the Sixth Circuit, there was a $70 gift card and a replacement blender blade, an option. No cash involved in any one of them. This case is so different from all of those where courts, dealt with the issue of abuses by plaintiffs' counsel. And here, try to be modest about ourselves, but our other 2 co-lead counsel, you're talking about some of the leading firms doing class actions, and we're not in it to kind of get windfall fees. And Judge Trenga, realized that because he was intimately involved in this case. He held status conferences every month. He and Magistrate Judge Jones oversaw the extensive discovery, 26 fact depositions, 10 experts, hundreds of thousands of pages of documents. So this was a hotly contested case. And the coupons here, again, comparing to these other cases, it ends up that on average worth $659 is the average coupon value, and the average price of a new floor was $1,100. So basically, for those who wanted coupons, they're getting 65% towards a new floor. Now, it is true that most people selected cash, but the coupons were also made available because, remember, this case involved formaldehyde issues and durability issues, but especially formaldehyde issues raised a lot of health concerns. And some of the class members were very concerned about that and had this feeling, even though it may have dissipated over time, the formaldehyde impact, there were a lot of people complaining about coughing, sneezing, lung issues, headaches. And so those people are probably the ones who selected coupons because they want to replace their floors. So this was real value and basically not the kind of abuse case that CAFA was concerned about. Let me look at now.
Mr. Toll, could I ask you, I will, full disclosure, what troubles me most about this award is this court remanded for a reconsideration of the fee order, and it seems utterly obvious to me and beyond any reasonable dispute that the district court decided that the number was going to stay exactly the same, and then I'll say configured the lodestar in such a way to ensure that the number would stay exactly the same. I don't think that's subject to reasonable dispute. I'd ask you why I should not be troubled, but what I think is what the district court obviously did here.
Well, Judge, I can't look into the mind of Judge Trenga, and I won't fight you on your views, but I think Judge Trenga was very careful. You know, when this case was remanded, it went back to him and we filed supplemental briefs. First thing he did was held the hearing. He had a number of questions he wanted to go over. He then wanted further briefing. He then held a second hearing before he made his decision on September 4th, 2020. But he was very familiar with this case, and he recognized that the counsel in the case, the co-lead counsel, had put in over $12 million worth of time. And the statute says on a case like this, when you don't value coupons, if there's a partial coupon, you know, you use the lodestar method. And he knew we had over $12 million worth of work. He also knew there was another $4 million by other counsel who assisted us that we didn't even put in for to support our petition, which would have lowered the multiplier to 0.6. So he awarded a multiplier of 0.8, which is a negative multiplier, of course. This is, again, not a windfall. In a way, we're not even making back our time. But, you know, he, I guess, felt it just was a fair and reasonable fee. And, you know, he clearly was aware of, you know, it took up a large percentage of the cash fund. But I don't, you know, he was, to me, he was very thoughtful about the statute and how it should be applied. And he did everything he was supposed to do. I can't look into his mind, but he obviously felt we deserved a fee of $10 million and that it was fair to re-award the same amount. And it was proper under CAFA.
Now, Mr. Cole, this is Judge King.
Yes, Your Honor.
We mentioned that possibility in the earlier opinion, did we not?
You did mention, Judge, you are
amount to be the same way or the same amount. And we said if the district court were to award the same amount of attorney's fees after applying the CAFA's coupon settlement provisions, that would not render the settlement approval order infirm in light of the deferential standard for reviewing such decisions. This is very deferential that we need to be for these district judges that are dealing with these kinds of things. It's all abuse of discretion, is it not?
Yes, you know, Judge King, you, of course, that was something I was going to mention. I don't want to harp on what went through your mind, Judge Gregory and Judge Quattlebaum at the time, but you clearly indicated that there was a possibility that Judge Trenga could award the same fee if he felt it was appropriate under CAFA. And Judge Trenga was, again, very thoughtful and careful. He even mentioned in his opinion, and Judge Hayton's, I think the obvious part of his opinion that I think is so powerful for us, of course, and contrary to what Mr. Clores argued, is he clearly stated, despite Mr. Clores' argument, that he gave, you know, no value to the coupons at all in his decision. But he also said, I am bearing in mind, this is page 10 of his opinion, the potential for abuse posed by coupon settlements and critically evaluating the claims of success on behalf of a class receiving coupons. So again, I think he was very careful, recognizing it might be appealed again, and went through what you're supposed to do in terms of making an award under Lodestar and considering measures of success.
How long was Judge Stringer involved in this case?
From the outset, Your Honor, back from 2015, when the case was, this was two MDLs that were transferred to him, and he's been overseeing this case since then. So, I mean, you can't find a judge who's more involved in a case. And again, I think very careful in how he went through his analysis. You know, the statute clearly allows the Lodestar analysis. He looked carefully at the Johnson factors and analyzed each one and recognized that. And then getting back, let me get to the measure of success, because again, Mr. Clore has misstated the record of what Trenga did. He did talk about the coupons or vouchers when he talked about measure of success, but he did not place a $14 million on them when he did that. And what he did just say is, you know, I think you can't ignore them. I'm not putting a value on them. I understand they're important and substantial to the people who select them. And I just can't ignore it. This was a good recovery by plaintiff's counsel, both of substantial cash and coupons that, you know, are valuable to those who select them. But he never said in doing the measure of success analysis that he was placing a $14 million value on them. So I think he did everything that, you know, a judge is supposed to do in terms of looking at it under the statute. In terms of or the objector Johnson's argument, and again, I don't fully understand this argument that the settlement agreement, you know, says it's 1/3 of $22 million. I mean, the settlement agreement could not be clearer. Judge Hayton's pointed out. It says it's the total value is $36 million. It says we're going to seek fees of up to 1/3 of that. This was another argument that was made that the objector Johnson said is that the settlement agreement nowhere says that the attorney's fees award is going to be paid out of cash. That is flatly wrong. It says it very specifically in the settlement agreement that any awarded attorney's fees shall be paid from the escrow account. And the escrow account is defined as in section 12B of the settlement agreement is where the cash $22 million is deposited. It is clear as a bell. And actually what is even, it's fortified is what the class members were told. If you look at the email notice, at the postcard notice, and the long form notice at JA all around 407.68 through 407.95, every single one of those documents says the cash portion will be used to pay the attorney's fees. Plaintiff's counsel can petition for up to $12 million. And the total settlement value is $36 million. It just could not be clearer as to what, you know, the facts are here with regard to what the class was told and what the settlement agreement said. So I think, again, in summary, Your Honor, it's really kind of gotten most of the points covered here. Now, one thing, again, to consider, and Judge Hayton's, again, you referred to—
Mr. Toll, can I ask you something?
Yes.
Can I ask you about something you said earlier?
Yes.
I want you to pretend for the sake of argument that there were no vouchers at all, that it was just $22 million in cash. We had to pretend the vouchers literally did not exist. Do you think this fee award would be reasonable then?
You know, Judge, I don't know if we would have asked for that amount. I just can't say. We probably would not have. I cannot think of cases where I've gone into a court on just a cash settlement and asked for 45%. So to answer honestly your question, I probably will not do that. And again, as class counsel here, Your Honor, there is no doubt in my mind of the value of these vouchers and their importance. And again, I don't, you know, it's outside the record. I hesitate slightly, but Mr. Bacharach—
Well, Mr. Toll, that actually brings me up. You know, you've said this several times, and I appreciate that you're being candid and you come before us and talk about the real world. And there's going to be, these are really valuable, and there's going to be a high redemption rate. And this isn't like these other cases because—
Well, Your Honor, you can't really be sure in these cases. In fact, you'll remember looking through the record that we made an estimate at the outset of how many people would claim, and we were way off. You know, we did an extensive notice program to try to get as many class members as possible to participate, and it was effective. This is almost like a record in a consumer case. We had 23.5% of claimants, of the class members, file claims. Most consumer cases are anywhere from 2 to 5 or maybe up to 10%. So we were way off in estimates, and trying to get an expert to then come in and say something about claims, it just, to us, is not the way to go. But again, Mr. Bacharach with, again, a statement about a high redemption rate is 10%. And again, I mentioned it outside the record, your honors can ignore it. We're already at 25% in 1 year of redemptions of these vouchers. And we have a 3-year expiration, but there are still 7 states that have no expiration, and 2 of them are the biggest in the country that had this product. So again, I don't know what the end result's going to be. If it goes at this rate, we may end up with 3/4 or 90% redemption. I don't know. And I suppose if you don't affirm, I guess Mr. Clore asks you to just reduce the fee, would be totally wrong. If you have any concerns about redemption, I mean, again, you could remand it and let it play out for another year or 2 until people can redeem. And actually, that we would still have quite a lot of people who could still redeem after 3 years. But that's one reason we didn't go this redemption route. That, some of these other coupon settlements have like 6 months redemption and that's it. These are long redemption periods. And we already, remember, we're going through COVID and we've got 25% of people already claiming these vouchers. So again, for those people, and we didn't know it would end up this way, Your Honor. We didn't know that class members would only end up with about $60 or $66, I think. We had estimated it would be much higher because we didn't anticipate such a high claims rate. But the vouchers ended up being close to $659 in value. So, and again, people, remember, there was an option. So people did not have to select them. Why would you ever select a voucher unless you're likely want to use them? Doesn't mean everyone's going to use them. We get it. But it's just a high likelihood most of the class members who chose vouchers will use them. So that's just a general view, and I hope that answered your question. But I think I've covered what I want, unless your honors have more questions.
All right, thank you, Mr. Toll. Mr. Barak, you have some time reserved.
Thank you, Your Honor. Jumping right in, Mr. Toll's off the record numbers turn out to be 3% of the class, because only 13% of the class chose coupons over cash. 87% of the class members chose the cash option, even though it's a great deal less in terms of the value, according to class counsel, about 10% of the coupon value, yet everybody wants the cash. Really, nobody wants the coupons. And the coupon redemption rate is 3%, which off the top of my head, based on $14 million, is $4.2 million in value, not 14 million. Mr. Toll said that the district judge did everything a judge should do, but that's not exactly correct, because what this court said last time around was it recognized that the district court had a fiduciary duty to the class. Fiduciary duty to the class, not a fiduciary duty to class counsel. So with regard to the attorney's fees being over 45% of the cash value of the class, that's not working within the fiduciary range of opportunities for the district court. It's a much larger fee than the court said last time around in terms of percentages than would be acceptable in this circuit. The court found that the 1/3 was higher than this circuit recognized, and that's why it came up with the $10 million figure, which was 28% last time around. It's true that it's troubling, as Judge Hayden said, that the court granted the exact same number second time around, because in doing that, the court didn't take into any consideration its knowledge that the fee agreement, the settlement agreement, and the notice all say that attorney's fees are going to be limited to 1/3. And of course, as the record shows, when he asked Mr. Toll about that, Mr. Toll said there was no limitation on the attorney's fees. Not that it didn't apply anymore, but it just wasn't there. So we believe that under Virginia law, which governs this contract, the court should take out that section of the valueless coupons, apply the 1/3 that class counsel agreed should be the amount of their attorney's fees, apply that number to the $22 million and direct the district court, or just enter the order yourselves, that the fee in this matter is approximately $7 million and not 10 plus. Thank you very much, Your Honors.
Thank you. Mr. Clore?
Yes, thank you, Your Honors. The court did not find that this settlement was good or exceptional. It found that it was satisfactory, and in light of the fact that we're dealing with approximately 800 million in revenue from the floors that are a dispute in this case, and it considered a $36 million settlement, which it found satisfactory and awarded a 0.8 multiplier. What we have now, class counsel have gone outside the record and suggested a 25% redemption rate, which 25% of 14 million is 3.5 million. If we indulge those numbers, you still only get to 25 million. The court wasn't going off of a $25 million settlement, it was going off a $36 million settlement. So you still need an adjustment. The reason class counsel didn't present this type of evidence, apart from the fact that, look, they didn't have the numbers at the time, the coupons hadn't been issued, but there's plenty of data out there that would have allowed them to extrapolate and come up with evidence as to what the redemption rates might be. And so the reason they didn't want to do that is they didn't want to present those numbers to the district court when it already thought that the $36 million settlement was just satisfactory. I want to address their distinctions of the 6th and 7th Circuit Court opinions, which were all coupons. First of all, the issue is still the same. You shouldn't be allowed to inflate settlement value with the face value of coupons. And the primary benefit here, as represented by class counsel, is the $14 million face value of the vouchers. So the rationale for requiring courts to look at redemption rates is still applicable. And then they didn't address the Easy Saver opinion from the 9th Circuit, which was both a cash and coupon settlement. And there, the court remarked that because it was also a lodestar and a percentage-based fee award, the Court of Appeals vacated the fees and said, because the district court incorporated the full face value of the coupons into both its percentage of recovery calculation and lodestar calculation of the fee award, this error requires recalculation of the fee award. So it's a distinction without a difference in this case that the 6th and 7th Circuit issued their opinions on full and complete voucher relief.
Mr. Clore, are you urging this court to find that whenever there is a coupon element in a settlement, it's per se not to be considered for fee calculation?
No, Your Honor, we're not asking for that at all. We're asking that if the court is going to consider the coupons, it has to grapple with the redemption rates and it has to look behind the face value of the coupons.
Right. So what you're saying, that your position is that the district court erred in not looking behind looking at the redemption rates, and that's the error you're saying, because you agree is abuse of discretion is the standard of view, right?
So actually, I don't agree that it's abuse of discretion. This is a interpretation of statute. Does a statute allow you to award fees under the lodestar method without looking at the redemption value of the coupons? And our position is that under 1712A, there's a mandatory obligation to consider redemption rates.
Well, it is abuse of discretion. What you're arguing is that an error of law is by definition an abuse of discretion, but it's abuse of discretion review, clearly. But an error of law can be an abuse of discretion.
Your Honor, I'm obviously not going to dispute.
Well, and we've got cases that say that the abuse of discretion doctrine in these attorney's fee cases is sharply circumscribed.
Correct.
Sharply circumscribed. We've used that language. I mean, Judge Tringa gets deference here.
I guess
Under
I'm sorry, Judge. Are you finished or?
Yes.
I was just going to say, I would agree with that position ordinarily. However, CAFA, application of the statute is not subject to discretion. The court had no discretion to choose to misapply CAFA, which requires, if you're going to attribute value to coupons, that you look behind their face value and consider redemption rates. So I understand the general deference that's accorded to district courts, but that deference doesn't apply when you're interpreting the statute.
All right. Well, okay. Nothing further?
No, Your Honor. Thank you. Thank you.
Thank you so much, counsel. We appreciate your arguments. We wish we could come down and greet you in our normal fashion in the Fourth Circuit, but we can't. But please know, nonetheless, we very much thank you for your arguments and your being here, and we wish you well. Stay safe and be well. Thank you.
Thank you, Your Honors.
Thank you.
Shake hands.
All right. Thank you. We'll proceed to our next case.
Assistant Federal Public Defender Laura Koenig, and I represent Appellant Francisco Palacios. The district court erred in this case when it denied the motion to dismiss under 8 U.S.C. section 1326D. First, Mr. Palacios was not seeking a futility exception, but rather was arguing that his immigration counsel's ineffectiveness deprived him of an opportunity for judicial review. This court should remand to the district court for further proceedings as to Mr. Palacios' challenge to the removal order because of his attorney's ineffectiveness. And second, the district court erred in denying Mr. Palacios' equal protection challenge to section 1326. Mr. Palacios presented sufficient evidence to show that racial animus towards Mexican nationals was a motivating factor for Congress to enact the crime of illegal reentry in the Undesirables Act of 1929. The government did not and cannot show otherwise. The later reenactment of the crime in 1952 did nothing to diminish Congress's original discriminatory intent. And the district court erred when it concluded that the Equal Protection Clause was not violated. On de novo review, this court should reverse.
Ms. Koenig, can you think of any situation where the Supreme Court or this court have ever held that a facially neutral federal criminal law is unconstitutional because it violates the Equal Protection Clause?
I cannot, Your Honor. I had intended to go through the 1326 argument, but because Judge Haytens had started out on the Equal Protection Clause, maybe I'll start there.
Feel free to start there. I'm happy to come back to it. No problem.
Okay. All right. The question the court must answer in the 1326D argument is, did the district court err in finding that Mr. Palacios sought to apply a futility exception under section 1326D2? And that was partially my issue in terms of inartfully using the word futile in the pleadings below. But a futility exception is just an exception to the exhaustion requirement that is simply based on a court's powerlessness to grant the relief that is sought. So for example, if a person in removal proceedings was just legally ineligible for relief from removal, there would be no basis on which they could exhaust administrative remedies. And that is the type of circumstance in which someone could seek to argue that there would be a futility exception. And that's not what we were arguing here. Rather, what we were arguing is that his counsel's ineffectiveness satisfied the requirements to further exhaust any administrative remedies available and deprived him of the opportunity for judicial review. And that's a distinct inquiry from whether or not someone is simply just asking essentially to disregard sections D1 and D2 of section 1326. And I briefly want to touch on Palomar Santiago at this point. In the government's 28J letter, they raised the issue of Palomar Santiago. And I think that the critical point for this court to consider as it relates to Palomar Santiago is in that case, the defendant there was asking the court to just simply disregard any showing as it related to D1 and D2. And that's not what I'm asking the court to do, and that's not what Mendoza-Lopez did. Palomar Santiago certainly did not overrule Mendoza-Lopez. And what Mendoza-Lopez recognized as it relates to that there are sometimes procedural defects that can render unavailable administrative exhaustion and deprive someone of judicial review. And so our argument here is that the ineffective assistance of counsel is what satisfies D1 and D2 of 1326 because that operated to deprive Mr. Palacios of judicial review.
Ms. Koenig, could you address the First Circuit's decision, which I think I understand your argument. I think it's a good argument. I think I understand how it works. Could you, Judge Lynch was not of the same view as you. So I'd like, could you give you an opportunity to respond to her counter analysis of D1 and D2?
Yes, Your Honor. And I think I hate to disregard a circuit court judge, but I think that Judge Lynch just got it wrong. I think because in Palomar Santiago's discussion, it uses the word excuse. And again, this is sort of, we're all trying to kind of figure out what language is the best word to use to describe what is actually going on. And in Palomar Santiago, when the Supreme Court said there is no excusing the elements in D1 and D2, I think that is where the First Circuit and Judge Lynch made the error. Because one way to describe satisfaction of D1 and D2 is there is a way to excuse D1 and D2, but there still has to be a showing. In Palomar Santiago, what the defendant there was just saying is, if I can show you that I'm not an aggravated felon, I have no further obligation under D1 and D2. And that's not what happened in Mendoza-Lopez, and that's not what we're showing here. We're saying that there would have to be a showing of ineffective assistance of counsel, and the district court would need to make further findings on that point, and also as to whether or not that effectively deprived Mr. Palacios of the opportunity to judicial review.
Counsel, am I right? You're saying, and please, you know your case much better than I do, but basically, are you saying that there's facial ineffective assistance here because counsel continued to press this, I am an Americanized person, and because I'm Americanized, I'm going to stand out, I'm going to be a target, when there is evidence in this record that his family had already been targeted by the gangs and failed to associate a clear connection with a social group is family? Is that basically what you're saying?
Yes, Your Honor, that is a part of it, because the district or the immigration counsel did not present the evidence of the people that were simply waiting in the hallway ready to testify that would provide support for that. But I don't think this court needs to get into that, because the district court just simply made an error of law in its analysis and made no factual findings. It would be more helpful, I think, for this court to review a record in which factual findings were made. But certainly, yes, Chief Judge Gregory, that is a record that exists in this case.
And do you agree with me? As I read the district court, it dismissed solely for failure to satisfy D2. Is that your reading of the district court's opinion as well?
Yes, Your Honor. And so this court would need to remand to the district court for further findings with legal clarification on what the standard is for D2 as it relates to this case, but for further findings on what the court would find as it relates to D1 and to D3. I want to make sure I have enough time to go on to the equal protection claim, so I'll move on to that now unless there's further questions about the 1326D challenge. Okay, thank you, Your Honors. As it relates to the equal protection challenge, I think the court has to answer two questions. First, whether strict scrutiny applies to the equal protection challenge in this case. And if so, then did the district court err in finding that Mr. Palacios failed to show that a discriminatory purpose was a motivating factor in Congress enacting the crime of illegal reentry in the Undesirables Act of 1929? As it relates to the first question, strict scrutiny we know applies when there is proof that racially discriminatory intent purpose exists, and Arlington Heights gives us the framework. The first step is that the challenger must show that proof that a discriminatory purpose was a motivating factor in enacting the law. And if that happens, then there is no longer the presumption of judicial deference to the legislature that would otherwise generally apply. And then the next step is that the burden shifts to the government, the law's proponent here, the government, to show that Congress would have enacted the same law even had the impermissible purpose not been considered. And then lastly, if the government cannot show that, which they didn't here, the court would then have to hold the law unconstitutional. And as it relates to the primary point that the government has made, that there is evidence of an economic reason that Congress enacted this, as the Supreme Court has recognized, there is very rarely a single motivating purpose with which Congress acts. And I think our record is replete here of, under the factors that the court considers in Arlington Heights, that this act in particular was motivated by racial discrimination. The first factor in Arlington Heights is whether or not the impact of the official action bears more heavily on one race than another. We certainly know that to be true. We know that Congress, at the time that the Undesirables Act was created, the only people that were being deported were Mexicans. I'm not saying not that there were never any exceptions, but the vast majority of people who were deported, which is a element that must exist before someone can be convicted of the crime of illegal reentry. That was the basis on which that was the factual basis there, that Mexican nationals were the ones being deported. And so therefore, we have the sequence of events that leads to the challenge action. We know that there's a history, a nativist movement happening in the United States at that time. A doctor had come to testify multiple times before Congress about very, very, very clear racial discrimination against people of other races, specifically Mexican nationals. And then the day that the act is passed, Congresspeople are on the, congressmen at that time are on the floor of the House saying, Mexicans are poisoning the American citizen because they are a class that's very undesirable. And minutes later, the bill passes the House of Representatives and our president signs it into law 3 days later. We also know that the relevant legislative or administrative history includes that similar information. And critically here, the government has made no showing at all to combat that. They simply just say, because the evidence that we presented indicated that the law itself was a compromise between the agricultural industry on one hand that needed growers, and they wanted people who were undocumented aliens from Mexico to be able to come and grow food for the United States. And Congress, on the other hand, that wanted to kick Mexicans out of the country, rather than creating a quota like they did for every other national. What Congress did in this case was to create a crime and criminally punish someone and essentially bar them from ever being able to enter the United States legally by enacting this law. And so the government made no showing whatsoever that racial discrimination was not a motivating factor. And so they have not met their burden. So this court can and should reverse on that point.
Ms. Koenig, can I ask you about something that I feel like is lurking in the background of this case, which is the history you have recited? I don't dispute any of it. It's extremely troubling to modern ears. I wish it would have been troubling at the time. This is a federal criminal law that has existed for almost 100 years, I think.
Yes.
And it seems to me that the argument you're making today would have been available at almost any point during the last, and even if I spot you that modern equal protection doctrine doesn't really exist until the 1960s, fine, I'll spot you that. This argument would have been available at any point during the last 60 years. And I don't think it would have been any different doctrinally than it is right now. What do I do with the fact that no one ever appears to have argued this until pretty recently, or at least in cases I've been able to find?
Well, you're right, and that's a very that's a good point. You know, sometimes the legwork is what is needed to be done. I mean, you'll see from the evidence that was submitted in the joint appendix that was related to this issue. This required people going through legislative history, and sometimes criminal defense attorneys, particularly federal public defenders or state defenders, don't necessarily have or devote the energy to do that. And so I don't have a good answer because I don't have an answer. I just know that it did require a fair amount of legwork, not much of which was done by myself, to create this. And I appreciate that. It's something that hopefully will be continued to be brought up as it relates to this. I did just want to touch very briefly on the reenactment in 1952, because that is what the district court relied on. As we've briefed.
How did you get around that reenactment in 1952? You're talking about everything that's happened in 1929, but it was
yes.
reenacted in 1952.
It was reenacted, Judge King, in 1952, but as we've briefed.
Judge Gibney thought highly of that point, didn't he?
He did, Your Honor. And what he focused on is that there was a reenactment, and he relied on a case, United States versus Price, which said that the views of a subsequent Congress form a hazardous basis for inferring the intent of an earlier one. But that misplaced or misunderstood what Price was saying. Price was looking at the actions of a later Congress when the one that was at dispute was an earlier one. That's not coming out the right way. But we have here, there is, as the Supreme Court has noted, for 100 years, if I can briefly finish my answer, Your Honor.
Yes.
That when there is no evidence that that Congress intended to change anything from one reenactment to another, and there are no substantive changes in the law, that this court must presume the intent remains the same. And we have that evidence here. We don't have that evidence here that there was a change. Congress could easily have fixed this, but they made no record to do so. Thank you.
Thank you. Mr. Atias?
Thank you, Judge Gregory. May it please the court. I'd like to start with the defendant's equal protection challenge. And our threshold argument here is that the defendant's equal protection challenge should be assessed under the rubric of rational basis review. As the court knows, the Supreme Court and this court regularly assess immigration-related laws under the rubric of rational basis review. And the reasons that dictate that narrow or deferential standard of review don't go away when Congress passes a criminal law. In our view, 1326 is rationally related to the government's undeniably legitimate interest in preventing illegal reentrance from the country. That view is supported by cases, for example, the Ninth Circuit's case in Hernandez-Guerrero, which is cited in our brief, which holds that 1326 is a necessary piece of our country's immigration architecture, and without it, our immigration laws would be all bark and no bite. That's the quote from the Ninth Circuit. And Congress, even as far back as 1929, as the Senate report from the 1920s shows, saw itself as addressing the problem of repeat reentrance. And under rational basis review, the inquiry should end there.
Well, can I ask you about that? The problem is, under rational basis review, we don't care what reasons people actually gave. We only care if we can hypothesize a reason. And so let me ask you, so are you really saying that if Congress passed a law kind of like this, that on the text of the law was facially discriminatory based on race, that we would apply rational basis review and uphold it because we can hypothesize a reason that's different than the one that's literally in the text of the law? I mean, that seems the logical implication of your claim that rational basis review would apply.
Sure. So number one, just to go back to the framework here, Arlington Heights we wouldn't need Arlington Heights in that situation because we would have a law that discriminates on the basis of race. But anyway, I don't think we'd be applying rational basis review if we had a law that discriminated on the basis of race. And then, of course, we need to know the purpose of the law. And we know from
Wait,
cases
so,
like
okay, so
City
then
of-
your argument is we apply rational basis review so long as the law is facially neutral? That's the position the government's arguing for?
So Arlington Heights usually comes into play when you have a facially neutral law and you need to then go into the depths of the law. But a law that Your Honor is suggesting, a law that discriminates on the basis of race, is unlikely to pass rational basis review, because laws that categorize on the basis of race or ethnicity or religion, as we know from cases like City of Clinton.
Oh no, I'm sorry. Let me imagine. I can hypothesize this law pretty easily. What if this law had a series of findings of fact, statements of congressional purpose, wherein Congress wants to end the scourge of racially derogatory term for Mexican Americans? We thus, for that reason, and Congress says in the text of the law, this is the reason we're doing it, we enact this statute. Would your argument be the same then?
This is I'm sorry, just to ask a follow-up.
I'm sorry, that's a bad hype. Imagine that the text of everything about this same law is exactly the same, but it's accompanied by a statement of purpose. And the statement of purpose is resolved to end the scourge of racially derogatory term for Mexican Americans. Congress enacts the following law.
Sure.
And it says in the text of the law, that's why Congress is doing it.
Sure. So a few responses. My main response is that rational basis review is not toothless. And we have examples of the Supreme Court, for example. Basically, courts are not obligated to blindly accept an asserted rationale that's not actually advanced by the statute, whatever the purpose of this statute would be. And I think the Supreme Court's decision in Trump versus Hawaii is a good example. The three cases that the Supreme Court cites are Romer versus Evans, City of Cleburne, Texas, and Department of Agriculture versus Moreno, which are three cases where the Supreme Court applies rational basis review, but looks at a law and says, no, there's clearly something more sinister going on here. And the purpose of the law is just not, the stated purpose of the law is not furthered at all by whatever Congress says they're trying to achieve by that law. My third response is that even in the immigration context, where courts have given wide latitude to Congress and the executive, from deferential review to even no review at all in certain cases, the Supreme Court has declined to rule out the possibility, and this is Reno versus American Arab Anti-Discrimination Committee, the possibility of an outrageous case, or where the alleged basis of discrimination is so outrageous that that general rule of deference basically just falls away. I don't know if we have that case yet, if we've seen that actually put into play, but that would be the type of situation, I think, where outrageousness review, or the possibility of outrageousness review that the Supreme Court left open in Reno, would come into play. We also have a good example in Trump versus Hawaii and this court's post-Trump case in IRAP versus Trump, the 2020 decision, where the Supreme Court applies rational basis review in a way that accommodates, sort of incorporates some of the concerns that I think the court might have. And the question, just mapping on Trump's rational basis inquiry to here, and it's not a perfect fit, but just to map it on, is number one, whether 1326 is rationally related to the government's interest in protecting against illegal reentry, and whether, notwithstanding the statements of some legislators, assuming they existed as to the actual challenged act, which they don't here, 1952 and beyond, but whether, notwithstanding those statements, it can reasonably be understood, the law, to result from a justification independent of the unconstitutional ground. So there is in the law a rational basis, call it an amped up rational basis, but a rational basis review that does accommodate some of your Honor's concerns. But just to get to the second part of the argument, which is the Arlington Heights inquiry, even if the court accepts that Arlington Heights is the right framework, or just assumes for the purposes of argument that Arlington Heights is the way to decide this case, it would hardly move the needle for the defendant's challenge. And on this point, we're really guided by two controlling cases. The first is Abbott, and the second is Raymond. And Abbott teaches us three key principles that guide us in deciding this question. The first is that legislators are entitled to a presumption of good faith. The second is that even a finding of past discrimination doesn't flip the burden of proof. And the third is that in any challenge like this, a sort of unique challenge where we're dealing with a progenitor law, the critical focus has to be on whether discrimination is proven in the given case, not in 1929, but in the actual statute that matters, which is 1326 as passed in 1952 and amended repeatedly since. And in Raymond, this court put into action Abbott's principles in a situation similar, not identical, but similar to ours, where a later in time legislature reenacted a law that this court had previously struck down as discriminatory and unconstitutional. And as applied to this case, the import of both Abbott and Raymond is really clear. Even if the court assumes for the purposes of argument that the 1929 law was passed entirely to discriminate against Hispanics, that doesn't do anything to prove discrimination as far as the 1952 law, because the defendant's historical evidence is almost exclusively focused on the 1920s, 1924 to 1929, and the defendant has made no showing that Congress in 1952 or beyond passed 1326, then Section 276, for discriminatory purposes. And
well, there is President Truman's veto of the and his explanation for why he vetoed the later law, right? What do you do with that?
Sure. Two responses. Number one, Truman is not a relevant decision maker. He is not a congressman, so what he believes about the law, good or bad, he should be treated more of a supporter or an opponent of the law. But that's my legal answer. My historical factual answer is that—
I'm a little surprised the executive branch is taking the position that the president's views are irrelevant.
I didn't say irrelevant, but they're not relevant as insofar as Congress's motives for passing the law are concerned. So that's my legal answer. My historical answer is that there is no evidence, and even the court in Carrillo-Lopez noted this, that President Truman vetoed the INA because of 1326. All the history indicates that President Truman vetoed the INA because of his opposition to the national origins quota laws. And that's what all of the debate was about around that time. And even the opposition in Congress, led by Senators Humphrey and Lehman, these are the Truman supporters who were vehemently against the INA and voted against the INA, their competing bill, which didn't include national origins quotas, but their competing bill had its own 1326, which is identical to the 1326 that Congress passed in 1952. So that would be my response, Judge Haytens. I want to point out why this case is even easier than Raymond. In Raymond, there were maybe 5 years. There was something like 5 years in between the later in time legislature reenacting the voter ID provision that this court had struck down. Here, of course, we have over 20 years. And in Raymond, and this is one of the concerns of the district court in Raymond, which is a fair concern, the legislature was substantially the same. The composition of the legislature was substantially similar, and there were the same legislative leaders. Here, as Judge Gibney pointed out, there's a 96% turnover. So we're not even dealing with a situation like Raymond. And just to sort of cap everything off, if you really get to the core of the defendant's equal protection theory, and the theory that I think the defendant is urging this court to adopt, it's really a theory that Abbott and Raymond have already rejected. The critical error in Abbott was that the district court put the onus on the law's defender to show that the later in time legislature had cleansed the taint of the prior discriminatory redistricting plan, and to show that the later in time legislator had a, quote, true change of heart. That was language that the court used there. And in Raymond, it was the same. The district court put the onus on the law's defender there in North Carolina to show that the later in time legislator, quote, purged the taint. And if you get to the
Can I ask you just, I would only say, I mean, aren't there recent Supreme Court decisions that call that into question? I mean, doesn't Ramos call that into, I mean, the Supreme Court has had some cases recently about this same broad issue, and in fairness, the Supreme Court recently has seemed to suggest just reenacting something doesn't make the bad thing go away. I think the court said that in Ramos. They've said that in some of the Establishment Clause cases, the Baby Blaine Amendment cases. What do I do with those cases?
So Ramos and Espinoza, the Montana case, first of all, those are not equal protection cases, and they didn't hinge on looking at a progenitor law as bearing on whether we could decide whether a later in time legislature was motivated by the same sorts of animus. So that's number one. But number two, first of all, I think Abbott is the most on point decision that deals with the situation, and then Raymond's application of Abbott is pretty much on all fours with this case. So I don't read either of those cases to require some kind of amendment or a requirement for a later in time legislator to amend a statute to sort of purge the taint. But even if there were such a requirement, we would have satisfied that here. And we've listed a few of the reasons, a few of the ways that that 1326 is different from the 1929 law, but I'll just list a few more now. Number one, in 1952, Congress included the founding clause. That's a substantive change that expanded the scope of liability, basically making 1326 a continuing offense until you are found in the country. This court in Ayam Brito pointed that out. In 1952, Congress struck the "in pursuance of the law" phrase. That's a phrase that in Mendoza-Lopez, the Supreme Court identified as a possible textual hook for the due process right that it would later identify, and that would be codified in 1326D. In 1952, Congress merged all three of the prior illegal reentry provisions into one provision. That with one penalty. That's a substantive change. That's not a copy and paste type of thing that Congress was doing in 1952. Congress also added a defense in 1952 that was not present in 1929, and that's now in 1326A to Big B. Congress also expanded the law to reach those who were excluded and deported, not just arrested and deported, and it also defined the word "enter" in the definition sections. So this is not the same law, and this isn't a scientific way of proving it, Your Honor, but if you look at 1326 as passed in 1952, it's about this big. If you look at the 1929 illegal reentry law, it's about this big. And one more just historical point I want to point out is that the 1929 law is not called the Undesirable Aliens Act of 1929. It was never called that. A more expansive provision was introduced by the House to the Senate's more streamlined illegal reentry provision. That provision included 7, later 8 categories of deportable aliens that the House wanted to basically tack on to the Senate's very narrow illegal reentry bill. Section 10 of the bill proposed the name, and this act shall be called the Undesirable Aliens Act of 1929. The Senate rejected most of the House's proposals, including its name, and the House receded from that. So the law has never been called the Undesirable Aliens Act of 1929. You will see that.
Can I take you to the threshold question, the 1326 question? I just want to make sure I understand what the government is currently arguing he should have done to satisfy D1. So am I correct? So he gets a criminal lawyer, and the criminal lawyer looks at his immigration proceeding and is like, wow, I have no idea why this was entered, because it never should have been entered, because your immigration attorney did a terrible job. Is the government's view before this court that what Ms. Koenig's colleague should have then done is to file, ask the district court to stay the criminal case so that they can file a motion to reopen under Lozada? Is that what the government thinks the criminal lawyer should have done in this situation?
No, I'm not. That's not our position. Our position is that under Palomar Santiago, when administrative avenues for relief exist to fix the error, that's the phrase the Supreme Court uses, alien has to take them, and he's not excused from at the time. So if the defendant believed he had a viable and effective assistance of counsel claim, he should have moved under matter of Lozada and actually litigated.
Well, but that's maybe a matter of forfeiture, but it's not a matter of exhaustion. A matter of exhaustion is just presenting it to the agency at some point, right? So you can think about 2254. You can exhaust before the state, even if you do it in a way that's untimely and thus forfeited. And then when you go to federal court and you're 2254, we don't say it's not exhausted. We might say it's procedurally defaulted, but not that it's not exhausted. So I presume if Ms. Koenig's colleague had said, let's continue this criminal case so that I can go file a motion under Lozada to reopen and thus exhaust, and thus in the government's view satisfy D1, my suspicion is that you would have opposed that. Is that a fair suspicion?
That's an interesting question, Your Honor. I hadn't thought about that. I don't know if we would have opposed it. I've never seen that happen, and the reason why is because I don't at this point, several years after the hearing for the IJ, I'm not sure the defendant could have moved to reopen under Lozada.
Well, wait, the government's brief tells me, look, the BIA is always open to arguing that these deadlines should have been equitably told until you realize the thing. And here the answer, sincerely, let's hypothesize that his immigration attorney, I don't know this person, I don't know their circumstances, but just did an objectively wretched job. Just imagine that for the sake of argument. And then he doesn't have that attorney, and it's not until he's tried with a criminal offense, he has a right to counsel under Gideon, and his public defender, doing exactly what they should be doing, takes a look at the immigration proceeding and says, this is complete garbage. You had horrible legal representation. You were obviously not eligible to be removed in the first place. And then he goes back to Lozada, and he or she goes back to Lozada. That would exhaust it, wouldn't it, even under the government's conception?
I think it would. I mean, motions to reopen can be filed. There's definitely, at any time, if you're removing an absentia, there's definitely equitable tolling. If a defendant qualified for that, then I don't think that would be unreasonable. I can't tell you what the government would do in every case, and I don't know what we would have done here. But that's an interesting point. But I think you're
sir. Isn't part of the reason that we don't know what would have happened here is that, as I read the record, the government never argued to the district court that he failed to exhaust because he hadn't complied with Lozada. I think the first time the government ever argued that was before this court.
That's correct. That's correct. The defendant hasn't argued that we've waived that issue, and as the court is aware, this court can affirm on any basis in the record. We're making that argument now. And of course, there's precedent. First of all, the defendant has to satisfy all the prongs of 1326D, and if he fails at any point, then his claim, his collateral challenge fails.
But can I ask, just to confirm my understanding that I also did with your colleague, I read the district court's opinion in this case to be based exclusively on a conclusion that he did not satisfy D2. Is that your reading of the district court's opinion?
Sure, and the district court dropped a footnote to that effect, stating that because I'm deciding the case on D2, I don't need to go to the other prongs. Sure, that is the district court's view, I think also. Just to tie things up with the 1 minute that I have left, regardless of what the court thinks of it.
Before you tie it up,
sure.
Make sure about the D2 in terms of not reaching 1 and 3, and that is not, of course, going to come into this court, for example, right, to appeal the BIA's decision, right?
Sure.
But if your lawyer has been so ineffective that you didn't raise those questions in terms of the proper social group or social group at all,
mm-hmm.
Well, wouldn't you, in effect, it's almost like not the kind of futile in terms of what you talked about, is what was talked about in distinction, but it is on the record. You forfeited those things, haven't you? Because then it comes before we'd have to review it based on what was presented, but it was never a proper presentation on that social group of family at all. It was only on the Americanization and those type of things. So isn't it waived in that? So it's beyond just D2. Don't you have to look at that ineffective assistance of counsel when that really is the nub of the problem?
Sure. So the defendant's futility argument is belied by the defendant's own conduct. If it was futile to argue for family-based persecution, then the defendant wouldn't have appealed to the BIA on exactly that ground. The defendant argued and took 3 or 4 pages of his brief to the BIA, citing all of this court's relevant family and kinship cases, saying that the IJ, there was the IJ's fault. Here it becomes Juan Ruiz's fault. But at the time, it was the IJ's fault. It was the IJ that had failed to account for an alternative basis for relief, their family-based persecution. If it was futile to go to seek further relief, then it would have been futile to go from the IJ to the BIA. So I don't think that argument really stands up. And however, whatever the court thinks of a defendant's ability to excuse compliance with D1 or D2, at the end of the day, the court has to answer the question of whether the defendant should be excused, which is a legal and a factual question, even assuming that the defendant that there exists in the post-Palomar Santiago world situations where a defendant can be excused from D1 or D2. The defendant's theory is that he would have been excused or should be excused because Juan Ruiz was ineffective. And for all the reasons we stated in our brief, and I see, Your Honor, I'm a minute and a half over time, for all the reasons we've stated in our brief, we don't think that that claim holds up, and the defendant at the end of the day has to be able to show prejudice, and on this record, he cannot do that.
All right. Thank you very much.
Thank you, Judge Gregory.
Ms. Koenig, you have some time reserved.
Thank you, Your Honor. Just a few brief points in response. As it relates to the equal protection challenge, as we've noted, and the Supreme Court has observed in Regents, immigration law can still be subject to strict scrutiny where there is proof of racial discrimination, as there is here. Second, as it relates to the Trump case that the government attorney cited in its briefing today, that was an analysis of a civil law. And as we've noted on pages 16 and 17 of our reply brief, the Supreme Court has found that sometimes a law that, or a practice or procedure that may satisfy a civil standard may not still pass muster when criminal punishments are attached as they are here. As it relates to the Abbott and Raymond cases, as we've noted in our briefing, those are different cases because there were significant intervening events that are not present here in the record. First, in the Raymond case, voters had approved a statewide referendum that constitutionally required the North Carolina legislature to enact a voter identification law. And that was the basis of the later enactment that was subject to challenge in that case. And in Abbott, the Texas court had drafted redistricting plans at the instruction of the Supreme Court. And those significant intervening events, there's no evidence of that here. And as it relates to the government's argument about the found-in portion that was added in 1952, the government attorney cited the case Ayon Ruiz that this court has found that is not a new element. It is simply just a conclusion of the reentry element. So the elements remained the same, the punishment remained the same, there were no substantive additions. And the evidence that we do have in this record about the 1952 reenactment does nothing to diminish a finding of racial discrimination. We know that when the 1952 law was passed, it was enforced via an operation called Operation Wetback. The names in this case are eye-catching and not certainly in a racially neutral way. As it relates to the motion to reopen, I think the court just doesn't need to engage in that at this point because it really is a purview of the district court to make factual findings as to whether or not such an administrative remedy would have been available to Mr. Palacios at any time that he could have pursued that. And so in conclusion, the district court just missed the mark on the legal analysis in Mr. Palacios' section 1326D claim. And this court should remand on that issue for findings of fact with clarifications of the law from this court. And as it relates to the equal protection challenge, the district court erroneously reviewed this case for rational basis and misapplied Arlington Heights. Mr. Palacios did prove that racial discrimination was a motivating factor, and the government did not respond with any evidence showing that but for another reason without consideration of the racial discrimination that Congress would have enacted the same crime. And so this court should reverse the district court on that issue. Thank you.
Thank you so much. Thank both of counsel for your arguments here, and we would love to come down and greet you as we normally do in our tradition, but we cannot. But please know that we very much appreciate your being here and your arguments, and wish you well, be safe, and stay well.
Thank you, Your Honor.
Thank you, counsel.
Thank you.
All right, would the court like to take on to our next case?
I think I'd prefer
I
the
defer
brief
to you,
recess.
All right, let's take a very brief, about with our next case.
Good morning. Good morning. May it please the court. My name is John Papa George. I am counsel for the appellants Forest River and Camping World RV Sales. The plaintiffs brought this claim under the Magnuson-Moss Warranty Act, in addition to state-related claims involving deceptive trade practices. After 9 months of routine litigation involving minimal discovery, a single day of inspection by plaintiff's expert, and mediation where 4 plaintiffs' counsel appeared and attended, the case resulted in a settlement where the plaintiffs obtained a replacement motorhome. Plaintiffs then filed a petition for attorney's fees pursuant to the Magnuson-Moss Warranty Act, and the court awarded almost $93,000 in attorney's fees. This award by the district court was issued.
And you think that's excessive, right, Mr. Papa George? You think that's grossly excessive?
Absolutely, Your Honor.
And you all bailed out of this case. You wanted to get out of this case really bad, and you got everybody to agree to seal it up, right? Absolutely, Judge. The Bowdens you didn't want any more of those product liability cases on these faulty RVs going on around the country. Yeah, so you bought your way out of this case. Isn't that right? I'm sorry, the last part. My apologies. I said you bought your way out of this case. Your client. Yes, Judge. You got the file sealed. You got the file sealed, right? Your Honor, the settlement agreement sealed? The settlement agreement was never presented to the district court. An affidavit of a Forest River representative was presented to this court. You didn't even present the settlement agreement. That's right. You don't want it out. But they came up with an expert report that really blew you out of the water. Well, they came up with an expert report that was 158 pages long and what could only be described as unreasonable. And that you say it was excessive work too. But on the basis of it, you bought your way out. Your Honor, we did settle in the interests of avoiding further litigation with the plaintiffs. And in addition, from a customer service perspective, yes, we did resolve the case. We replaced the plaintiff's motorhome with a new motorhome. And following that settlement, plaintiffs sought a very large sum for attorney's fees, and the district court erred in awarding $93,000 for 2 reasons. And the issue of fees and costs were reserved in the settlement agreement. Yes, they were, Your Honor. Plaintiffs they were reserved for litigation. So that everything was settled except the fees and costs, and that went to Judge Hilton. That is correct. That is correct. And the district court, Judge Hilton basically gave them what they asked for based on the time that they had spent and the expenses, including the $18,000 in expert fees. And you all thought that was too much. We did, and the reason we thought it was too much was you had given them somewhere or another there's an affidavit that put in the terms of the settlement agreement, and you gave them a new RV plus some money. We gave them a new RV and $5,000 for camping expenses, and the district court erred in awarding them. Even though the settlement agreement's not in, somebody put it that much in an affidavit that you don't contest. The settlement agreement is not contested in the sense that the parties settled the case. What is contested is the amount of... You said the settlement agreement is not in the record, or not. What was it before the district court? It was not. That's correct. Only the affidavit. There was an affidavit that said what the settlement agreement was. There was an affidavit by a Forest River employee that explained the terms of the settlement, which went to the important issue of the success that was achieved by plaintiffs related to the terms and the facts stated in that affidavit were not contested. In the affidavit of the Forest River employee, that is correct. They were not contested. And so we know, and Judge Hilton knew what the terms of the settlement agreement were because they were in the affidavit.
Yes, Judge Hilton knew that the plaintiffs received a replacement motorhome, and he knew what the value of that replacement motorhome was, plus the additional fees for the camping fees. But
was the value of the motorhome was what, $147,000?
Originally, yes, the value of the motorhome was 140. Well, that's what they purchased the motorhome for, was $147,000.
The value of the replacement motorhome. The value of the replacement motorhome was $147,000. That's what I said.
No, the value of the replacement motorhome was $22,000. The invoice
so
cost.
it wasn't worth $47,000.
Not the
first
replacement.
One was worth $47,000, and the second one was worth $22,000.
Yes, the replacement motorhome was worth $22,000, and the reason is because you take the value of the cost of the new motorhome, which was $121,000, and you take the value of the old motorhome that had the warranty issues, and that was $99,000. And the affidavit outlines that the value of that replacement was then $22,000. And then Forest River and Camping World also paid an additional $5,000 for the camping fees. And that gets us to the point of the success that was achieved. And that's the second consideration for why the district court erred in awarding the fees. The first is the hourly rate evidence was insufficient to establish that the rates sought by counsel aligned with the prevailing rates in the community.
Mr. Bennett's affidavit, Mr. George.
Yeah, Mr. Bennett's affidavit says that in paragraph 13, my apologies, paragraph 11, that his firm charges $750 an hour for his work, and then he had the rates for the other two attorneys. But the affidavit does not contain any evidence that the rates sought by Mr. Bennett and his firm aligned with the prevailing rate for other consumer protection lawyers working in the same community and involving cases of the same complexity. And this was not a complex case. And so what plaintiffs did...
It was not a complex case, but I'm not sure that's right either. But the affidavit in paragraph 13 has got an extra knot in there. This was an affidavit, and you did too. It's really a declaration, but the declaration was filed in support of the claim for attorney's fees.
It was, but it did not.
And if the knot means anything, it undermines the attorney's fees claim.
I would agree with you 100%, Judge.
Which convinces me pretty readily that the knot is a clerical error.
Judge, it very well could be.
Because if it means anything, it undermines the claim for attorney's fees. And the declaration was submitted, and it says on the cover sheet, declaration in support of the claim for attorney's fees. And Mr. Bennett was lawyer representing the plaintiffs making a claim for the attorney's fees. And somebody put an extra knot in there, and I don't know why they didn't clean it up. And you all you didn't raise it with the district court, but you raised it on appeal. And you raised your opening brief, and you raised it again in your reply brief. I'll agree with that, but you didn't raise it with the district court.
Your Honor, but what we did raise, and I would agree with you that it is likely a typographical error, but the plaintiffs...
Typographical error doesn't mean anything. Now, but that's the big basis of your assertion that they're asking too much money.
No, Judge, the primary basis... The primary basis...
on the first page that supports the claim. And he says how much work they did and all that stuff, and they got a settlement out of you all, and you didn't want any more of these lawsuits. And that's pretty apparent too. I mean, I didn't come over on the pickle boat. Let me tell you, I've been in lawsuits on both sides of these things, and I've been around a lot of settlements. And you can tell when, particularly in product liability cases, when the corporate manufacturer wants out. They want out quick, and they'll get out quick if they can. And they don't want any more suits that look like this one.
Your Honor, but $93,000 in attorney's fees for 9 months of work is on its face unreasonable,
Well,
and that's
according to Judge Hilton, it was within, and he cited this Metro case, whatever it's called, from 2011 in the Eastern District of Virginia, in Alexandria area. He relied on that, not just on this affidavit with the extra knot in it, but he relied on this other case up there about the rates of lawyers, and they are compared to what they were when. And I didn't practice in that area, but I practiced when lawyers got $25 an hour sometimes. But they get big rates now, and particularly up there in Northern Virginia, around D.C. And he said in 2011 they were getting rates like this. Judge Hilton did. He's been around a long time too, and he's seen a lot of lawyers come through there, a lot of law firms.
Your Honor, the Grissom case clearly
says it's reasonable. Judge Hilton says this is reasonable. We reviewed after abuse of discretion, and our review is strictly circumscribed of whether he abused his discretion or not. So you got an uphill with me on his attorney's fees.
Judge, I did gather that, and if I may.
Yeah.
The Vienna Metro Matrix involved a $100 million real estate dispute involving lawyers from Kirkland and Ellis, and Mr. Riley did a survey of hourly rates of very large international law firms. With all due respect to Mr. Burge, who I know and have litigated across the country, those firms are just not simply the same type of law firms. This was not $100 million. You know, other cases have said that, including hair color for men, that if it is not a complex commercial case, this was a breach of warranty claim. And I understand there's some argument that the motorhome is certainly a potentially complicated vehicle, but at the end of the day, the hourly rates
prepared a report that was 150 pages. Explaining what was problem with this motorhome. I mean, there's a lot of work went into that, which you challenged too. You said it was a waste of time, but it certainly looks to me like it convinced you all to settle quick.
Judge, with respect to the Vienna Matrix, however, what the law requires plaintiffs to do is submit evidence that the rates that they are seeking coincides with the rates in the community. They did not submit any evidence from any consumer protection attorneys that attested to the type of work that the plaintiffs' counsel did or that the type of hourly rates they sought. The affidavits from Mr. Bennett and Mr. Burge were vague. There's no indication that they have received those hourly rates from other courts, no indication that clients have specifically paid for those hourly rates. And when you combine the vague evidence from those two lawyers plus an affidavit from a case that involves $100 million 11 years ago, there is simply no evidence.
Mr. Papa George, can I ask you about the two areas that I worry about most for your case? Do you practice regularly in the Alexandria division?
I do not.
Well, okay, so I guess as a descriptive matter, it is my sense that district judges in the Alexandria division use the Vienna Matrix all the time. And so I'm wondering whether they're just sort of, as a descriptive matter, it's my sense that they do that. But then let me ask you about something specific to your case. Can we talk about likelihood of success and what I'm supposed to do with this sentence on JA 38? Plaintiffs have prevailed on all elements necessary on all claims. Now, maybe that was an unwise stipulation that you now regret, but I don't understand how that's not just ball game on the degree of success factor. I feel like you stipulated that they had a complete success, and so I don't think it's a stopple. I don't know exactly what it is, but I don't know what to do in a world where you're asking me to say they didn't succeed when the parties stipulated that they succeeded on all elements of all claims. Could you address that?
Absolutely, Judge. And I would point to Hensley versus Eckerhart, United States Supreme Court, that concluded that a prevailing party only gets to the statutory threshold. And in this particular case, we would agree that the plaintiff.
Well, right. Whoa. But that's very different. Hensley says that as long as you prevail on one claim, you're still a prevailing party, even if you lose on 7 other claims. But that's not what you stipulated to. You didn't stipulate that they prevailed on all elements of one claim. You stipulated they prevailed on all elements of all claims. That's very different than Hensley.
Your Honor, I see that my time is up, but may I finish?
Yes, you may.
Thank you, Judge. Your Honor, the fact that we stipulated that the plaintiffs were a prevailing party does not result in a district court the district court still must engage in a lodestar analysis. That's a separate bucket. We have a bucket of prevailing party, and we have a bucket of what I call the lodestar bucket. And critical to that is the determination of the hourly rate. And there was simply no evidence, I've covered this point, of a prevailing rate in the community. In addition, the findings, which Hensley tells us have to be very clear, and that the district court must make clear what its findings are related to the success. That's the third prong of the McAfee and the Grissom cases. What is the success achieved? You can be a prevailing party, but yet not achieve the success you initially sought. Because you have to remember, we're looking at over $500,000 of an initial request: treble damages, emotional distress, anxiety, lost time, all related to this motorhome. And at the end of the day, the value is $27,000. And I would go so far as to say that's not even close to what they were originally seeking. And when the success is limited essentially, then Hensley tells us that you can reduce the fee award when the scope is limited in comparison. And that is what has happened in this particular case. So bottom line, you have no evidence of hourly rates, and you have findings that do not establish that the court considered the success achieved, which was much, much less than was originally sought. And I am now 2 minutes over, so I will stop, and I will reserve the cost discussion for rebuttal, if that's okay.
Thank you, Mr. Papa George. Mr. Wessler.
Thank you, Your Honors. May it please the court, Matthew Wessler for the appellees. I'd like to make 2 brief points, and then I'd be happy to answer any questions the court has. First, although the defendants have raised a number of arguments in their challenge to this garden variety fee award, the district court below addressed and rejected them pretty squarely. Of course, the defendants disagree with the reasons given by the district court, but that is not, under this court's highly deferential, and as Judge King emphasized, sharply circumscribed standard of review, a basis to overturn the district court's conclusions. And the defendant's own best cases illustrate the point. In both Robinson and Grissom, the only reason that this court overturned a fee award was for legal error. On occasion that happens. For instance, if a court approves a particular rate without any corroborating evidence. But that is not what happened here. The main challenges the defendant has pressed: that the fee was excessive when compared to the plaintiff's success in the case, that the district court gave too much weight to the corroborating evidence of reasonable rates, or that the costs were excessive. Those are all issues that fall within the heartland of a district court's discretion on the question of fees. And as this court has explained time and again, the standard of review for fee awards does not empower an appellate court to disturb those aspects of a district court's decision.
Mr. Westman, can I ask you about something that just hung me up the moment I started reading this case? And I don't know it matters here because I think any such argument is forfeited, and I don't think it goes to our jurisdiction. I don't understand how you can do this at all. There was no judgment. The plaintiff did not get a judgment from the court. It's a private settlement. There is no court-ordered consent decree. On what basis does a district court award fees in support of a purely private settlement that doesn't result in a consent decree? I'm not sure your client is a prevailing party under the statute when you have a private settlement. Have you ever? I've never seen a case like this. Could you tell me why I shouldn't be worried about that, other than it's totally forfeited and we don't have to do it, thank God?
Yes. So obviously, I think you're right that it is forfeited, and it doesn't matter for this court's jurisdiction, of course, because there is a final judgment on the fee award, which is what this court reviews. I think Your Honor is right to be perplexed about how this case got to this posture. And I think candidly, there might have been a technical defect in failing to seek a judgment approving the settlement in the way that you might think. But I don't think that stands as a bar, even on its own, to the award of attorney's fees, because under the statute here, which is 15 USC 2310, a consumer can obtain awards so long as they quote unquote finally prevail in any action. And the way that the Fourth Circuit has understood the term to prevail, it isn't not an absolute categorical requirement that there either be a judgment or a consent decree, or even that the court incorporate a private settlement agreement into some order. This comes, and I know this wasn't briefed, Your Honor, but I'll tell you anyway, it comes from this court's case in Smith versus Rivera, where after Buckhannon, what the Fourth Circuit has said is that to show that a party has prevailed, the party must, and I'm quoting, demonstrate that it has received some of the relief it sought in bringing the lawsuit in the first place. So I think it's on that basis that the plaintiffs here would qualify as prevailing parties that would then entitle them to fees.
So just to close this off, let's say, oh, I'm sorry, Chief.
No, go ahead. You want to close it up? Go ahead.
So you would tell me, if I'm troubled by whether this satisfies Buchanan, that the way I get around that is to say, I don't have to decide this case. We can decide this case in a way that doesn't decide whether this is valid under Buchanan, because it clearly doesn't implicate the district court's subject matter jurisdiction, and we clearly have appellate jurisdiction under 1291, and anything else is forfeited and non-jurisdictional. You think we can say that?
Absolutely. That is exactly how I would urge this court to resolve that particular aspect of this case. Yes.
Thank you, Mr. Wessler.
Mr. Wessler, my question is this: on the stipulation, my concern is that the district court may have conclusively relied too much on the stipulation in determining the third level of the lodestar, which is the degree of success. And that is, it says, the pertinent part of the stipulation is that the success, quote, on all elements of all claims. Now, you can succeed on all claims, but get very little damages. You see, because it didn't say the damage is not a claim. So you get damaged because you succeeded on the claim. That's all it said. It seems like the district court just sort of took that and said, okay, when I get to the third level, what they are asking for has found no reason on the level 1 and level 2 of lodestar, so therefore they get it, and that's what he did. But don't you have to do more? It's like Mr. Papa George said, and when you distill what you got, it was about $27,000 in terms of in that extent. So how can you just say, oh, stipulation is there, they get it? Don't you have to see what you really got?
Yes, 100%, Judge Gregory, and the district court did that here, and I'll point Your Honor to J403, and this is of the district court's opinion, where it actually looked not just at the stipulation to justify its award of the fees, but it actually looked at the degree of the plaintiff's success, which was as the colloquy between Judge King and Mr. Papa George revealed in the record in this case. Now, it was not the settlement agreement.
No, follow through now. You said they looked at it.
Yep.
Well, if you look at it, they didn't get treble damages.
No, they didn't get treble damages.
Well, when you look at it, what do you get to justify $90,000?
Oh, well, right. So, I mean, the actual terms of the settlement are under seal. So, I can point you to where they are in the record, which is at J415.
No, I'm not talking about getting into all of those things, proprietary things like that. And I'm talking about looking at what the success was. We know what that is. You got another RV for $127,000. The first one was $147,000. We know the salvage value, the value of what you got, $99,000. That's just arithmetic. So we don't need to go into the seal because we don't want to do that because that's the purpose of being sealed. We don't talk about it in public. But that's what you got. Forget about all the other stuff there. When you look at that, how can you, it seemed to me the district court clearly said, Katie barred the door. you stipulated that you won on everything. Therefore, I see no reason to reduce this at all when I get to level 3 in terms of dispute. Tell me where that's resolved.
So again, J403, I'll just quote you the language. So after the statement in the district court's opinion where he identifies the stipulation, there's an additional sentence in that same paragraph. And he says, after comparing the degree of plaintiff's success to the amount in controversy, the court finds that the proposed fee award should not be reduced. Now that language indicates that he went beyond the stipulation and actually looked at what the plaintiffs got. Now the defendants have a different—
it's $27,000.
With respectfully, Your Honor, I disagree. That's what the defendants say their view of the value of this settlement was. That is not the—
I mean, what's your view? Give me the numbers. Don't go into the substance.
The reason the numbers are different— Yeah, Judge
answer
Gregory,
my question. What is your view of what the success was in terms of number?
Over the amount of the new RV plus the additional payment that the defendants made for an additional warranty and the expenses of travel and camping. And the reason is because—
What's that total?
I don't have the number in front of me.
You ought to know the total. You know your case. You're coming here saying 27,000 is wrong, and you ought to be able to tell me what number is right.
The reason 27,000 is wrong is because the old version of the RV was worthless. So it doesn't equate to just subtract the price of the old RV from the price of the new RV. And so—
Wasn't there annoyance, aggravation involved in dealing with this thing?
Well, there was, Your Honor. There were other—
I'm going to get into that too. Why did you let them seal all this up?
Your Honor, I can't speak to that. I wasn't involved in the sealing below. So—
Are there? There's no top secret CIA information in here anywhere.
I'm sorry, Judge King.
How does this run-of-the-mill product liability case end up sealed completely?
Your Honor, I'm sorry, I don't have an answer. It's possible that my opposing counsel will be able to answer that question. I wasn't involved in the litigation below.
And they say they have to, there's a settlement agreement wasn't even presented to the district court. They argued, although it's in an affidavit. And why didn't you rebut that point about the not being in paragraph 13 of Mr. Bennett's declaration?
Again, I think that was an oversight.
You left that for me to try to clarify.
Yes, Your Honor. We do agree it was a clerical error, as you said. I think it was an oversight not to have addressed it in the response brief in this case.
Nobody proofread it. You just wanted to get your check and get out of town.
I would agree with you that there was some degree of sloppiness when it came to the affidavits in this case. But again, I think I would urge this court to recognize and understand that the standard of review here is very circumscribed. Judge Gregory—
We did, but no question about that. We all agree with that, and we've written opinions that said that. And that's the best thing you've got going for you.
Yes, I will add, if I could, I would just add that,
if people go to court with lawsuits, they ought to be open and transparent. And they should only be sealed for good reasons, not to protect the defendant or the plaintiff from publicity over the amount of a settlement or terms of a settlement or the fact of a settlement. They ought to be open and above board, transparent. Transparency in the court system is pretty important. And I mean, I don't just blame you. I blame the plaintiff and the courts and everybody. We've had discussions about that, and we've amended these sealing rules. And there got to be, should be good cause shown to get these things sealed up.
Mr. Wessler, if I ask you something that's sealed, please, you have every right, and I encourage you to say, no, Judge, that's sealed. But can you help me and just stop me when you get to that point? But your client paid $147,000 for the RV that turned out to had to be replaced, correct?
Yes.
Was there a lien on it?
I don't believe so, Your Honor.
Okay, so that was outright owned, okay, right? So you're saying that they potentially, let's keep this value the same, they turned in $147,000, and we know depreciation occurs with vehicles, but let's for the sake of argument, we forget about that for right now and assume that there was no depreciation. So they turned in $147,000 asset and received $121,000 asset. Is that right?
Yes, Your Honor.
Okay, all right. So with my math, subject to depreciation, of course, that looks like about $26,000 in the red for your client. I mean, on the paper, I'm sure that was depreciation. So then you got what, $5,000 for camping expenses to accomplish the transfer of the vehicles. That's the, okay, that's about, 30 some, whatever, $31,000. Where's this value that you're talking about? What am I missing in the arithmetic here?
There's nothing in the arithmetic that you're missing, Your Honor. But the plaintiff's claim is that they got a defective RV that was worthless. And this is in the briefing in this case, and I'll point you to page 17 and 18 of our brief in this court.
But what does it matter? What does it matter? Let's assume you're right. Let's say it was worthless. And it was $147,000. You get paid for it. It's worthless. If they gave you a $127,000 vehicle, what difference does that make the numbers change? You now, like I said, you're 20. That's why I said you're $26,000 in the red. I understand that, but the numbers still. How did the numbers change?
The numbers. I don't think the numbers changed. The question is, Your Honor, I'm not quite sure if you're asking whether they prevailed or whether the fees were excessive.
No,
if you're asking,
I'm going to the point that the point is that the district court seemed to put too much emphasis on the fact of the stipulation that was all that had to be done for the step 3 of the lodestar. And when you said in response to my question, well, the court looked at the degree of success. So now I'm drilling down with the success. And I don't come up with more than 30. So I see 3 times the lawyer's fee is 3 times what your client got.
I understand if you just rely on the numbers, but from the client's perspective, they had a $0 RV, and then they were able to obtain an updated and new RV. And from their perspective, they went from 0 to 120, whatever it was, $20,000. Their economic damages on their claims they recovered fully on those. They were not left. They were made whole when it came to their economic damages.
I don't see how. I mean, I know numbers pretty well. I just don't see how you come up with that. Those are the kind of damages that the other ones you didn't prevail on, like the frustration and all those things. But in terms of pure number, they had a $147,000 asset that you say, I'm giving you credit for that was worth nothing. I get that. But it was replaced with an asset that's $121,000, which you have not disputed was worth what it was, $121,000, right? So that means that what really should have been a $147,000 asset, now because of that transfer, they got $121,000. They're still $26,000 short. They got $5,000 for ancillary travel type camping, but the numbers don't lie. So what I'm saying, and then I'm not saying you're lying at all, but what I'm saying is the numbers are the numbers. And you still, I knew it had to be frustrating to your client because that's an incredible investment for anybody, for your family. You're looking at the travel. I'm not discounting that at all, but that was not any of the damages factored here. If that had been the case, that's a different matter. Right now, we're talking about numbers.
I understand, and I may not be able to persuade you on this point, but from the standpoint of success prevailing on the claims that they made in this case, they were made whole. They did not suffer any economic damage, any lingering economic injury after the settlement. And I would suggest, Your Honor, that even if you can't, add or subtract the numbers to get to some particular number that you think would authorize prevailing party, I have not seen in any of the cases that the parties have cited in this brief, and I've done my own survey since after reading the briefs, which the Fourth Circuit has reversed a district court for its assessment of the degree of success related to the amount of fees that it determined were reasonable. The only
problem we got in this case is that you have the stipulation, and the record clearly indicates a great deal of emphasis and weight was put on that stipulation in fulfilling the third step of the lodestar. And that seems to be a problem. That's what I'm asking you. And you've answered, I'm not going to answer, you've answered the best you can and forthrightly. So that's my problem here. You're right. Normally we don't. But when you have a smoking gun that there's evidence that the court picked it up and was influenced by it, that can't be ignored, notwithstanding that normally we don't.
Well, I understand, and again, I may not have persuaded you on this point, but
well, I'm saying you don't know. My argument, my question is, you don't know what I'm going to do.
Fair enough.
I always think that, but
yes,
I wouldn't do that. Go ahead,
Mr. Wessler. Can I ask you about costs? So I see the argument that the Camping World's argument about costs is totally forfeited because it was never presented to the district court, which I think they acknowledge in their reply brief. And that's, again, probably sufficient to resolve this case. Do you have any response on the merits? Because I got to say, I'm left thinking their costs argument is totally forfeited, but it may well be right. And do you have a response on the merits that they're wrong as opposed to forfeit?
Yes, Your Honor. I mean, I think this is a difficult and unresolved question. And the reason it's difficult and unresolved is because the cases that the defendant has cited here, Rimini Street, Crawford Fitting, don't involve a statute that looks anything like the Magnuson-Moss Warranty Act, 15 U.S.C. 2310. There's a key difference. And if you look at Rimini Street and you look at Crawford Fitting, in both of those cases, the Supreme Court is looking at statutes that just refer to costs. In Rimini Street, it's a copyright statute, 17 U.S. 505. And it says, in an action under this title, the court in its discretion may allow the recovery of full costs. What the Supreme Court said in Rimini Street is costs is a term of art that doesn't include expert fees. So unless Congress specifically articulates in the statute that expert fees are included as costs, we're not going to infer it. But the statute here, and I realize I'm about to run out of time, and I'll briefly summarize, 2310 D2 actually says that a consumer who finally prevails in any action is allowed to recover as part of the judgment a sum equal to the aggregate amount of costs and expenses. And it's that additional language and expenses that the Supreme Court has not yet weighed in on about whether that second aspect of recovery expenses does include an ability to recover expert fees. Typically, that is where Congress locates the phrase expert fees. Now, is that a winning argument? No, I don't know that it is, but it certainly suggests, to me at least, that there is nothing about this question that is already decided or foreclosed by the Supreme Court. And as you know, under this court's waiver jurisprudence, what the defendant would have to show in order to be entitled to a decision on an issue that it has waived is not just plain error, but fundamental error, something that goes to the integrity of the proceeding. And I don't think that this question, which is an open question, is anything close to that would meet that standard. I see my time has expired. If the court has no further questions.
Judge Gregory, I have a couple of questions.
Yes, go ahead, Judge King.
And on the cost thing, I second the issue being raised by Judge Heitens. I appreciate it because the opening argument, they didn't get to their cost argument, but which they didn't raise or present to Judge Hilton. But going back to the value of the settlement, you said once that the RV they bought was worthless, and they paid $147,000 for it. That means they're $140,000 out of pocket. I don't know why you would agree that they came out ahead here. The $147,000 they lost, and then they had to deal with the fact that they had a lemon vehicle, and then they had to bring a lawsuit, and they had our counsel, and then they settled for, apparently, according to the affidavit, for something that was worth $127,000. Well, that'd be the out-of-pocket number, $127,000.
Yes, Judge King, I agree with all of that.
Then you agreed with Judge Gregory that it was worth $147,000. Is it worth $147,000 or is it worth nothing?
Yes, Judge Gregory, Judge King, you are right. I did not intend to concede that somehow the plaintiffs were in the hole. I don't even think that the defendants in this case have taken that position. So I believe the way you just described it is exactly correct. If there are no further questions.
All right, very good. Thank you. Mr. Papas George.
Thank you, Judge Gregory. In my remaining time, real quick, I feel like we beat this horse a little bit on the value, but I just wanted to clarify one thing, Judge. The original purchase price for the motorhome that was originally purchased by the plaintiffs was $147,000. And that's what I would describe over in, I keep using the word bucket, but I got the old motorhome over here. The new one that they replaced was actually a newer model, and it had a wholesale value of $121. And remember, when they bought the older one, that was a retail value.
What was the retail value of the new one?
Pardon me?
What was the retail value of the new one?
Your Honor, there is no evidence in the record of what the retail value of the new one is. The defendants focus on...
You represent it, and you're here, so I'm going to ask you what the retail value is.
I would say that it's greater. I would say that it's greater than $147,000 given the RV market and how much it exploded in the last 2 years. Yeah. So, okay. But when you look at the success issue, you focus on what the value of that new one is, and the defendants clearly focused on what the invoice cost was of the new one minus the wholesale value of the old one. So either way, Judge, we're in that $25,000 to $30,000 range, and
well, you're not. If it was worthless, they paid $147,000, and it was worthless. They're out of pocket $147,000.
Judge,
they're out of pocket $147,000.
But they were not out of pocket because they received a new one.
Well, they were paid $147,000, and it was worthless, is what the man said. And that's what the complaint says, I think. But what are you going to do about your cost claim?
Yeah,
I want to get that because you didn't argue that earlier.
Here's my final point on the value. The district court did not even go into all this discussion that we've had about value. The district court didn't even discuss it, and I'll leave it at that. And that's our primary argument on why that award based on the fees was in error, because there was no discussion. Quickly, with under 3 minutes left, on the cost issue. The first primary issue, again, is the district court's failure to address the reasonableness of the cost. Looking at the plaintiff's report...
Did you present that to the district court?
Yeah, we did. We did present the unreasonableness of the cost to the district court. We argued that $29,000 was unbelievably unreasonable. In fact, if you agree with us that the value of the RV is $27,000, and I recognize there's a dispute, but if you agree with us, Mr. Bailey charged more than the value of what the plaintiffs got.
But to clarify, Mr. Papa George, you never argued to the district court this category of expenses is categorically not recovered as costs. You never argued that to the district court, did you?
We did not argue to the district court that the costs were not recoverable under Section 1920. We did not. What we argued was a reasonableness issue. That issue was going to sort of put the sword in me here. That issue was identified after the district court's opinion, Judge. I would argue that if this case gets remanded, I think there's an issue out there as to whether we can then make that argument on the second go-round, because you would assume that the plaintiffs would get to make the argument that the hourly rate coincides with the prevailing rate. But I'll put that issue aside, because what the district court did not do was an analysis of whether that $29,000 was reasonable. there was no discussion about the fact that Mr. Bailey took 34 hours.
What's the standard of review for that? Is it plain error, or can we review it at all?
Judge, I would.
It wasn't reviewed by the district court, and you raised it on first time on appeal. Is that plain error review, or is it something else?
Well, we did raise the reasonableness of the costs, and Judge, I would argue that that standard of review is an abuse of discretion, but I would also argue that the district court clearly got it wrong, and in part because the opinion didn't outline any of the facts regarding the $29,000 for the expert report. All the judge said was the defendants have made a Daubert-style attack, and therefore I'm going to reject that, and I'm going to award $29,000. He did not look into the fact that it was 10 times more than the defendant's expert, that 34 hours measuring moisture when water was visible. I'm not sure why it took so long when you could see the water damage, which is why we resolved the case. And all he focused on, the judge, was the Daubert-style issue. And I think that's a separate issue. This is reasonableness. And in the whole, and is a scope issue, $29,000 for a replacement, when the expert report costs more than what the plaintiffs received, something is inherently wrong. And the same argument could be made for the fees when, and I think affirming this decision is going to send a chilling message. This is my final comments on this, is going to send a chilling message to defense litigants, because very little work was done in this case, very little discovery, a mediation, 4 lawyers at mediation. We've sort of ignored that at this point, but to have very little litigation, settle a case, and then all of a sudden 9 months later, the defendants are looking at $121,000 or $124,000 combined award.
Whose idea was it to seal this thing up? Well, that was your idea, right?
The settlement agreement contained a confidentiality provision, Judge, and that is why.
No, but that was proposed by you, by your side.
Because we didn't want to breach the settlement agreement by
that was proposed by your side to seal everything up. That's right.
And the only thing we sealed was the affidavit.
What was the value placed on sealing everything?
To not breach the settlement agreement.
No, the monetary value of sealing it for you.
Judge, I don't think there was any monetary value to sealing it. The sealing, it had nothing to do with trying to protect the defendant's reputation or anything like that. I mean, these defendants are routinely involved in litigation.
Unseal it now?
Assuming the plaintiffs have no objection to the confidentiality language in the settlement agreement, sure, we would do that. Your Honor, I am way past my allotted time. And
I just want to make sure it's clear, this argument about it would resolve the case on the waiver, at most, that would be only for the cost, not for the attorney's fees. Correct?
Oh, right. Absolutely.
Right, exactly.
And that gets to the final point of what does this court do? And our position is you have 2 choices. You can remand it for further evidence of hourly rates and further consideration of the success, or this court has held that a fee should not result in a second major litigation. And if this court determines that those fees are wholly unreasonable and those costs are wholly unreasonable, this court has the right, as it has done, to reverse and pick a number and say we think this is reasonable, and it's reversed.
Okay. Thank you very much, counsel.
Thank you all. Thank you, Judge.
Thank you both for your arguments. We can't come down and greet you as we would like to do, but know very much that we appreciate your arguments and being here, and wish you well and be safe. Thank you, counsel.
Thank you.
We'll proceed to our final case for this morning.
Good morning. May it please the court. My name is Jack Ryder. I'm here on behalf of Kinsale Insurance Company. May I proceed, Your Honors?
You may.
Thank you, Your Honors. As a threshold matter, our position today is that Kinsale is entitled to judgment as a matter of law when the court examines and applies what we believe to be a clear and unambiguous pollution exclusion that was set forth in an endorsement that explicitly states that it replaces and supersedes the earlier policy language. That endorsement provided that it precludes coverage for any loss, damage, expense, or increase in loss, damage, cost, or expense, which arises from any kind of seepage or any kind of pollution and or contamination or threat thereof. And the pollution exclusion further defines seepage of pollution and or contamination to include but not be limited to the seepage of or pollution and or contamination by anything including but not limited to any materials designated as a hazardous substance by the United States Environmental Protection Agency. Now, it is not disputed here, Your Honors, that the acetone and methanol, the chemicals that released vapors, that the vapors that seeped out and would ultimately ignite the flame that was on a table, those were in fact hazardous substances and therefore fall clearly within the definition of pollutants as used within the exclusionary language. And
Mr. Ryder, can I suggest, I think you're clearly right on the noun. I think this is clearly a pollutant. I don't understand how you can construe this contract for this not to be a pollutant. What I'm not sure you're right about is the verb. And you kind of are skipping over the verbs, but the verbs also strike me as important. Seepage, pollution,
yes, Your Honor.
Or what's the third one?
Well, I think the main verb is seeping, Your Honor, is what I think Your Honor is referring to.
Yeah, and I guess what I would say to you is when I hear the word seep, that does not to me convey what you're arguing here. When I hear the word seep, I'm thinking of a barrel that has a liquid in it, and the liquid is sort of leaking out of, I guess I'm thinking of seep as somewhat similar to leak. I just don't think as a matter of plain English usage, what you're suggesting here falls within at least the unambiguous meaning of the word seep. And would you like to help me with that?
Absolutely, Your Honor. And I think we can look together at the term any kind of seepage as utilized in the policy language. And I'll just point out parenthetically that this exact pollution exclusion has been found to be unambiguous by at least 3 or 4 different courts that we've identified in the brief. But here's what the language of the exclusion says on the question of seepage. The term any kind of seepage or any kind of pollution and or contamination as used in this endorsement includes but is not limited to seepage of or pollution and or contamination by anything including but not limited to here, let me see if I can find, I want to find for Your Honor the exact language.
Sir, I appreciate that.
No,
it's sort of circular because it says seepage is defined to include seepage. And then the other 2 verbs that were in the original definition, which I understand you probably didn't write this contract, doesn't strike me as a particularly useful definition to repeat the verbs being defined.
Well, I guess, Your Honor, I completely understand the court's point, but the term seep or seepage, I think if one were to look at the ordinary language, and quite honestly, I don't recall that either the district court or the other side explicitly challenged the concept or the word seepage as being ambiguous. Now, I would.
But you'd agree that you all wrote this thing, right?
Well, yes, Your Honor, and as I indicated,
you all wrote it. That's right. But now I want to get back to something more basic. How do we get jurisdiction here?
Over this case, Your Honor, the district court certified it for immediate review under 54B.
Under Rule 54, neither side briefed the jurisdictional point, but you say we got jurisdiction under 1292A1, I think, which governs injunctions. Is there any jurisdiction under that statute?
Your Honor, I believe
no
no, Your Honor, I believe that the jurisdiction of this court lies entirely under 54B as a matter certified by the district court as one that would assist in expeditiously evaluating issues pertinent to the overall.
It's an interlocutory appeal, correct? You say it's a final order appeal. Is it an interlocutory appeal?
Your Honor, I believe that 54B is construed as a final judgment for purposes of this court's jurisdiction.
But what's left on the table? What was left on the table?
What's left to be adjudicated, Your Honor, are breaches of contract and bad faith claims brought by.
What's the value of the claim here? What's the amount of money? He ordered you to pay the claim. What's the number that applies to that claim?
Well, Your Honor, I believe, well, the amount of the policy, I believe the amount of the claim and the amount at issue still remains unresolved, and that is going to be heard.
So that's on the tape. That's a jury question to be resolved, correct?
Well, that's correct, Your Honor, but the issue of whether or not the policy.
So the value, the amount of the claim is yet to be resolved by jury. So it's no question this is an interlocutory order.
Yes, Your Honor.
Mr. Ryder?
Yes.
Can I ask you, my understanding is that this is the district court certified a final judgment under Federal Rule of Civil Procedure 54B. Is that correct?
That is correct, Your Honor.
And I guess my understanding has been that when the court does it, those claims that have been resolved are a final decision under 28 U.S.C. 1291, not 1292. Isn't that right?
That is also my understanding, Your Honor. And if we cited 1292 in our brief, which I don't believe we did, Your Honor, but if we did, that would have been a mistake and an error on our part. But I didn't think that we did, but if we did, I apologize. This is a 54B certified final judgment because the district judge concluded that it would facilitate the disposition of this issue was a threshold issue that could expedite the conclusion of the entire matter. So I do believe the court does have jurisdiction, and I don't believe that's been...
The other side resisted that. You made the motion, and the judge granted the certification the next day without getting a response, and they came in and moved to vacate it and said it was not appropriate for an appeal, which they've apparently abandoned on appeal for some reason. But we have an obligation to satisfy ourselves, even though neither party has briefed it. We have an obligation to satisfy ourselves that we have jurisdiction. That's the reason I'm raising the question, that neither of you briefed it.
Absolutely, Your Honor.
And they resisted it. They resisted it in the district court. Anyway.
Yes, Your Honor. The basis of
it is the 54B certification, I agree. Is it an appropriate 54B certification is what we have to decide.
Yes, Your Honor. And first, I will say that you are correct that it was resisted by a motion for reconsideration that the district judge spent approximately, I think, 6 weeks addressing or examining before he issued his ruling. And so he did take the time and gave the other side opportunity to address 54B. And again, you are correct that the other side has not advanced any challenge to this court's appropriate authority to review a 54B court to the extent it's requested. We will provide it. I, of course, want to get back to Judge Hayton's question if I'm, about the issue of seepage, because I don't want to, if I may, Your Honor, Judge King.
Well, you go ahead, unless you have something further to say on jurisdiction. I just was what I asked about jurisdiction because we have to decide that first. And you
totally.
all haven't briefed.
Understood, Your Honor. And our position here is that this is a final judgment.
The fact that you say there's jurisdiction and the district court says there's jurisdiction and the other side says there's jurisdiction doesn't give us jurisdiction.
Yes, Your Honor. And you are correct. And I would submit that once 54B certification is provided by the district judge, that creates a final judgment under 1291, which vests this court with jurisdiction. And if we need to provide any sort of supplement, Your Honor,
we have to decide whether it's an appropriate 54B, which is interlocutory. It's an interlocutory order. There are issues remaining to be decided, including how much the claim's worth. And this is an odd situation anyway, because you're the insurer. And they made a claim against you, and instead of denying the claim, you sued them. This is your insured. It's the insurer suing the insured. Usually these things come up in the other direction.
Your Honor,
the insurer is usually suing for coverage. You sued them to say there wasn't any coverage without denying the claim. You've never denied the claim.
Your Honor, lawsuits for declaratory relief in terms of a question examining coverage, I would submit are not completely out of the ordinary and can in fact be quite common in some jurisdictions. So I think here, when Kinsale filed their lawsuit, there were a few points that were raised. And specifically, our position is that the pollution exclusion does in fact bar coverage here. And the reason we believe it does, I want, again, going back to the issue of seeping, Your Honor, I would submit that the ordinary definition, the ordinary dictionary definition, or a plain language of seep to flow out slowly, or to emit slowly, or to be something to be emitted, to seep here, Your Honor, I would submit is not ambiguous. And I would also respectfully suggest that when we look at the fact that here it is undisputed that there were vapors that were flowing, seeping, emanating from these canisters, and that those vapors were highly flammable and were in fact ignited, it is our position that at least at a minimum, we believe that as a matter of law, that should be deemed the efficient proximate cause of the loss here. And at a minimum, it's a question of fact. And we've cited multiple cases from various jurisdictions, including, of course, the Murray case, that talk about the fact that the efficient proximate cause doctrine presents a question for the trier of fact. Now here, I think it is critical that the undisputed expert testimony that was provided by Kinsale came from two different witnesses. One was George Harms from the West Virginia State Fire Marshal's Office, and then Allison Brenneman, an arson investigator that counsel, the other side, doesn't even address Ms. Brenneman's affidavit in their brief. And Ms. Brenneman testified, and this is in the record at Joint Appendix 2190 and 2191, that the tabletop fire, and we acknowledge that there was a tabletop fire. That was the first event that was a, quote, fire, unquote. But according to Ms. Brenneman, the tabletop fire ignited the flammable vapors and, quote, had the chemicals not been present and had only the plastic ignited, the fire would have been contained to its area of origin, assuming the proper use of fire extinguishers, unquote. That is undisputed expert testimony that I don't believe JDBC even addresses in their answer brief. And the bottom line is that at a minimum, the efficient proximate cause here, the qualitatively predominant cause of the loss, is a question of fact that should have been relegated to a jury, although we believe that based on—
Yeah, counsel, can we move to that? So far you've been focusing on your swinging for the fences argument, which is that not only should the district court not have granted summary judgment against you, it should have granted summary judgment in favor of you. Can I ask you to take a minute and to make what you think is the best argument where, at minimum, the court should remand for something other than summary judgment in favor of one of the parties?
Absolutely. At a minimum, we are entitled to a trial on all of these issues. And here's why. At a minimum, Murray and other cases have consistently held that in overwhelming number of cases, what constitutes the efficient proximate cause of a loss is the question of fact for the jury. So at a minimum, it's not up to the district judge, and perhaps not even up to this court. It's up to a trier of fact to listen to the evidence, to hear the expert testify, and to make a decision about was the predominant cause of the loss, not the first, not the last. When there's a concurrence or a conflagration of events that arise in the chain or link in the chain, a question for the jury is to decide which one of these events constitutes the predominant cause of the loss. That's a question for the trier of fact. And
is your view also that the estoppel issue would be at minimum a question for the trier of fact?
Absolutely, Your Honor, absolutely. And I'm happy to go through every nuance of that if Your Honor would like me to turn away from the pollution issue. I see that I only have a few seconds left. If I may use some of my rebuttal time to address that question, Your Honors, if I may. Let's talk about the issues of the estoppel, because here, I believe that is overwhelmingly a question of fact. What we know about this case on that issue is that, first of all, construing all inferences in favor of Kinsale Insurance Company, we have an initial application at JA 267 that says that sprinklers were, quote, being installed, unquote. At Joint Appendix 244, a supplemental application said that the fire suppression had been contracted to Brewer Sprinklers. Now, it would later be admitted that nothing had been done. None of the sprinklers had been installed. The plans for the sprinklers had not even been submitted at that time for approval by the state, and that's at Joint Appendix 636. Now, Emily Meyer, Kinsale underwriter, testified at Joint Appendix 1524 that, quote, at the time of binding, my assumption was that sprinklers were installed. And she explained that at the time the application was presented on September 6, 2019, she believed that the idea that the sprinklers were, quote, being installed, unquote, she interpreted to mean, as she testified, that she presumed that they were in the process of being done, and believed that by the time the insurance was issued later on, several weeks later, or a week later, rather, she believed that the sprinkler system would have been concluded. And the timing here, Your Honors, the timing gives rise to, I believe, very significant questions of fact. And here's what I mean when I talk about timing. The JDBC had borrowed from the Small Business Administration, and under the facts of this record, they needed to close the loan by September 6th. And that means they needed to have insurance coverage in place by September 6th. Now, on August 31st, Brian Coakley, the chief executive officer of JDBC, advised Mr. Wilkins, the broker, that the loan was closing on September 6th and, quote, JDBC needed to have insurance in place before that, unquote. That's at Joint Appendix 1422 through 1424, which means that there was only 3 days to bind insurance because of the September 3rd, because there was a preceding holiday. So between September 3rd to September 6th, Mr. Wilkins had to procure insurance for JDBC in order that JDBC could acquire the loan from the Small Business Administration. So what I would suggest to the court is that they submitted the application, they said sprinklers were being installed, and then we have further indicia that there was an understanding by Kinsale that at the time both of the application being presented and at the time that the insurance policy was bound, that there were in fact protective safeguards in place. So for example, I would ask the court to look at our supplemental appendix 94 and 95, SSA 94 and 95. Why these documents are important, and this is all discussed in our briefs, is because these documents present contemporaneous at the time business records from Kinsale manifesting a belief that there were in fact sprinkler systems and theft protective measures in place at the time the insurance was bound. So for example, at SSA 94 on September 6th, 2019, the day the application was submitted, you will find that there's references there from Emily Meyer, who also testified in this case, that, quote, all safeguards are in place, unquote. At SSA 95, Emily Meyer wrote a note in the Kinsale, these are internal documents that say, all security measures are fully operational. And she describes the safeguards and it says, sprinkler is being installed. If we look again at the internal notes on October 23rd, 2019, there's a document, a notation from Will Farmer at Kinsale, who writes P1/P2 in place. P1 and P2 were the protective safeguards for fire. And it says security system being installed currently with remaining P9. That's the protective safeguard for the theft measures. So at a minimum, on estoppel, which is a fact issue, and examining all inferences in favor of Kinsale, which, against whom the judge ruled on the summary judgment, I would respectfully submit that at a minimum, it is a question of fact for the jury as to whether or not estoppel applies when we have clear disputed issues as to whether or not Kinsale believed, based on internal documents created at that time and testimony, that there were in fact protective safeguards in place at the time they issued the insurance policy, particularly when we have all this documentation that says that the sprinklers are being installed, that theft measures have been already installed, when in fact we would later learn that none of that had been done, none of it. So that's why I think, Your Honor, at a minimum, we have significant questions of fact. As I mentioned, I know I'm deep into my rebuttal time. So unless there are any questions about either the exclusion or the issues of fact, I would reserve on the remaining time. Thank you.
Thank you. Ms. McMillan?
Good afternoon, Your Honors. My name is Stuart McMillan, and I represent JDBC in this appeal. This was a fire loss, pure and simple. The undisputed record shows that Kinsale has already conceded that in its briefing below with the district court. As the underwriter, Kinsale knew exactly what it was insuring. It issued a quote, it accepted applications, issued a quote, bound a policy, and conducted an inspection, took pictures, wrote a 7-page inspection report of the facility, and then accepted an $80,000 premium. That's undisputed. To fully understand this case, we have to put context to it. And that's one of the things that is glaringly missing from the appellant. This JDBC was to be one of the largest manufacturers of hemp-derived products. It uses a process, a closed-loop process, whereby solvents are used for the extraction process. Kinsale is an insurance company that specializes in offering coverage for this very industry. They understand the process. They understand the solvents that are used in this process. And Kinsale, in fact, has its own specialized and proprietary underwriting guidelines specific to this industry. In the summer of 2019, my client started a build out of preparing its facility to extract hemp. As part of that, it needed insurance, correct. Kinsale needed business, undisputed. In this, we filled out an application like all of us do at some level with respect to trying to secure insurance. In that application, and one of these is a Kinsale application and a basically standard Accord application. My client discloses that the fire suppression system is being installed. It also talks and discusses the manufacturing process, identifies the very solvents that are going to be used in this process as it is used throughout the industry. That application was provided to Kinsale. They had both applications. Kinsale then issues a quote. In that quote, there is a block whereby you can indicate your contingencies. In the quote provided by Kinsale, there's no contingency. Oh my gosh, you don't have your fire suppression system completed, therefore we're not going forward. That's fair. Underwriters do that all the time. They control the process at that time. But in this instance, there was no contingency except one of really relevance here, Your Honors, and that was we're going to conduct an inspection. Kind of what happened in the Colony case this court dealt with 3 or 4 years ago. The inspector goes to the facility and goes around the facility, takes pictures of the solvents, the barrels. It understands that the actual fire suppression system is being installed. It says it 3 separate times in its report, the same language that was in the application that was provided.
Mr. McMillan, let me give you a hypo that illustrates why my instinct is that this estoppel issue is a jury question. I agree with you on the following. I think we can agree on the following. This contract says you have to have a fire suppression system or they won't pay for fire damage. I think that is undisputed and true. I think it is also undisputed and true that the day they bound coverage, there was no fire suppression system and they knew it. But and that they inspected later and there was no fire suppression system and they knew it. I think those things are all undisputed. But what I think is also undisputed is that your client repeatedly represented it was going to install one at some point. And so let me give you this hypothetical. I want you to imagine this fire happened 5 years after the inspection. And 5 years later, your client still had not installed a fire suppression system. Do you argue that they would be stopped then, that by binding coverage based on a promise you were going to do something soon, that they had for all time contracted to pay for fire damages, even if your client, in contrast to what it said, never installed a fire suppression system?
Your Honor, first of all, I think that these policies are renewed every year, so 5 years is a tough hypothetical. But the answer to this is how I'd answer this question. When we wrote being installed, that is actually very true. And let me say to your point, we had hired the sprinkler vendor months before the application. We had paid half of that contract, over $40,000. We had, Your Honor, a fire hydrant connected to and had municipal water run to the facility. We had pipes delivered. So I think, in fairness, to say that we kind of made a false promise, I don't think it's fair on the undisputed record. But if we went to your hypothetical and that we just weren't going to do anything at all with it, there would be more, I guess, favor of opinion that, hey, maybe this ought to go to a jury. But we don't have that, Your Honor. Because
but that's my question. To me, this case comes down to, what did the parties reasonably understand being installed to mean? And what is the scope of what a reason? Because I agree, they bound coverage knowing that you hadn't installed it yet. But it wasn't based on a we didn't and we're never. It was based on a we're going to do it soon, or we're in the process of doing it. And once we're into a estoppel like that, we're into the realm of equity, and we're off to the races about what reasonable people understand things to mean and what a reasonable amount of time to do something is. And that seems really, really facty to me. It does not seem like summary judgment-y to me.
Your Honor, being installed means one thing, and that is that it's not installed. There's no really disagreement that being installed does not mean installed. And as I was indicating, being installed is actually a very accurate portrayal. But Your Honor, the reason it doesn't go to a jury question is when your inspector comes there, and as an underwriter, they have three options, Your Honor, that they can do when they go do their inspection, which is 11 days before the fire. They use the same terms we do, being installed. Everybody knows that it was not completed. And in that, they have three options.
But Mr. McMillan, I'm glad you pointed out that 11-day day. If you told me, if I come to your house and I say, you haven't done something you're supposed to do, and you say, I know, I'm so sorry, but it's being installed. Again, I'm not saying that I necessarily think they should get summary judgment, but if you told me something was being installed, I would expect that it would happen within the next 11 days. I don't think that I would understand being installed to mean 11 more days are going to pass and it's not happened yet.
Let me answer it this way, Your Honor. When we filled out the application, that was in early September. We utilized the term being installed. And as I indicated, the reason for that is we had a vendor that we had already paid, and they'd already started. We had water and the hydrant already put to the facility. We had pipes that were there and brought in. The point I was making is they knew when they did the inspection in late October that it had not been installed. And my point is, Your Honor, under their own guidelines, and as an underwriter, they could simply do this. They had three options. Hey, you're not complying with what you put in your application, so therefore we're going to return your premium. Number two, we're going to basically say, hey, there's non-compliance, give you an opportunity to quote, get it installed or fully completed. Or three, you make a deliberate decision to move forward and bind and uphold the coverage or provide the policy and provide the insurance. Your Honor, that's why this is not a summary judgment case on estoppel at this point. The case law is very clear. The actual control rests with the underwriter. It had the opportunity to say, we're not going to do this. Its eyes were on the field. It knew exactly what it was doing. So the idea that somehow, hey, you put assign some temporal aspect to it, that has no real meaning when you're actually there and you see it, and you have three options under your own guidelines. And they chose.
And Mr. McMillan, I agree with you that would absolutely be true if the fire happened on the day of the inspection. I absolutely agree with you that would be true if the fire happened on the day of the inspection. I'd probably agree with you if it happened the day after the inspection. I guess it's just less obvious to me that you say they have these options. I mean, I don't think your client can go back to what their options under the contract were, because the moment we talk about estoppel, we're conceding that under the literal language of the contract, your client loses. And your client is the one making an appeal to equity for an equitable exception to what the contract otherwise would say that we do in this situation. And at that point, I think we're talking about what a reasonable person would understand and how a reasonable person would rely. And it's just not obvious there's also the principle that equity helps those who help themselves. And I just think there's an argument to be made, I guess I'll say, that equity does not protect a person who doesn't do something they're supposed to do, promises they're going to do it, then promises again they're going to do it, and 11 days later they still haven't done it, and then they get to the benefit of equity. Again, I'm not really suggesting that I think we enter summary judgment against your client on estoppel. I just think, to use the language I used with your friend on the other side, it is an awful big swing to me to say this is so overwhelming in your favor that you get summary judgment on it.
Your Honor, fair enough, but I understand your point. The reason that it is not subject to summary judgment from our client perspective is understanding the seminal law in West Virginia about estoppel in the context of an insurance company, and understanding the concept that an underwriter controls the risk. And if the underwriter knows about facts, in this instance, that the fire suppression was not completed, it has an obligation to make that known to us. That one of the things missing in your scenario is that somehow they came back to us and said, hey, you haven't done this, you're making these promises. That's not a fair assessment of the record. In fact, we submitted an application and there was silence. We did not even know. We were working to obviously get things up and running. We wanted to go in a full manufacturing process. But Your Honor, the way the case law works in estoppel, it's clear fundamental law in West Virginia that if the underwriter knows about these facts, but continues to go forward and issue a policy, then they are going to be bound by that. To come back later and say, oh, wait a minute, this wasn't installed, therefore we were excluding it. That's why estoppel can be made as a matter of law here. Your Honor, what is your best case for that prop? Sorry, Judge King, go ahead.
Mr. McMillan, I want to change gears. That's what I want to do. I don't know, maybe Judge Hyden needs to finish, but I still don't understand the jurisdictional answer here. You all took the position there was no jurisdiction for this appeal with Judge Bailey, and then you didn't raise it when you didn't even brief it when it came down here.
I'm going to give you a very practical and candid response. And that is,
you wanted to get it over with.
We wanted to get this case moving as fast as we can. Our company, yes, sir.
You have an obligation to tell us that there is jurisdiction or there's not, and you conceded there was jurisdiction for some reason, or tried to, which you can't do, because we have to examine it ourselves.
Your Honor, you're correct that subject matter jurisdiction is something that the court must discern, and no matter what the parties say. But I was giving you the practical response is I got a company that has got sued and hasn't been paid for over 3 years and is essentially going underwater and becoming extinct. So that was part of it. But the second issue is this, and all I can say is it's under Rule 54B. You have to understand the actual complaint itself that was brought by Kinsale is a complaint for that there is no coverage. That was the extent of the complaint. And to that end, the court ruled that there was coverage and that you should have paid the claim and should have paid it 3 years ago.
But you didn't resolve the claim. You didn't resolve the claim. We don't know how much you're claiming. You don't have determination of the damages.
Well, we asked the court.
You have the Judge Bailey ruled there's coverage. All right, how much are they going to pay you if we uphold him? You don't know. You haven't had a trial yet.
Well, Your Honor, actually we do know.
So
because
it's interlocutory. It's interlocutory any way you look at it. So
well, Your Honor.
Resolution of the claim.
Your Honor, with respect to the value of the claim, it's $7.5 million. Our position is very clear that in their complaint, they never disputed the damages of the case. But I want to make that very clear.
They don't agree that that's $7.5 million.
Well, what they stipulate to after the fact doesn't.
If you all can agree that it's $7.5 million, then that's what we got to resolve here, is whether they want to pay you $75 million. But Judge Bailey didn't rule that they didn't enter a ruling that they want to pay you $7.5 million. He just said there was coverage. But for what? The value of the claim. He said that would be resolved later. We'll hold that off till later. That makes it an interlocutory appeal. It's not a final order. Any way to look at it.
I understand, Your Honor. One of the points I'll make with respect to Judge Bailey, he ruled that the claim should be covered. It was in some of his orders on some discovery issues that it was always a policy limits claim. What the point being is that they've never raised in their complaint, oh, by the way, there's no coverage and what you're seeking is only worth X dollars. My point of it is that's how the court got to where he got, is in other words, that the coverage and the limits should be paid. That has always been his position because they never, even though they sued us and didn't actually deny the claim, they never put in their lawsuit there was some issue as to the value, that it was somehow less than the policy limits.
So, Mr. McMillan, can we assume that if you had sued them for failure to pay the claim, is it fair to say that you would have sought way, way, way more than $75,000 in damages?
More than yes.
As in way, way, way over the amount in controversy. Or if you had commenced a lawsuit against them, the amount of money you would have requested would have been vastly above the amount in controversy requirement.
Yes, that is true. Your Honor, I'd like to, with all due respect, to talk a little bit about a couple of things. First of all, dealing with the efficient proximate cause, the most efficient proximate cause. Your Honor, I think that analysis is getting a little distorted. It's set out in West Virginia's case law. It's also set out in Couch. What you're looking for in that case is the but for. And this, again, is undisputed in the record. This was a heat gun set on a table, caused a fire. If that didn't happen, we would not have this loss. That's the but for. That's why in the Matthews case, the court was able to, and that's the Supreme Court out of West Virginia, was able to affirm a summary judgment. You can look at that and determine that the efficient proximate cause is undisputed, and that is in the record. In all due respect, the comment made by counsel by some sort of expert that somehow blew that theory out of the water is absolutely untrue. This expert that was identified in a declaration in a reply brief, which we would argue is not a part of the act, should be waived in and of itself. But in that representation by that expert, she's not disagreeing with the fire marshal and how the fire started. What she is trying to hypothesize and speculate that it got out of control because of, the vapors, and that caused this fire to be a lot worse. That's not the issue and germane to the analysis of efficient proximate cause. And I would ask this court to realize that this has been set forth in the Matthews case and can be done. I also, Your Honor, with all due respect with this seepage, this is not a seepage case. Judge, you're square on. We know what seepage is. These barrels, many of which they took pictures of during their inspection, were sealed containers. This isn't something where it's leaking out and encroaching on groundwater and causing some sort of problem. This is nothing but seepage. And Your Honor, this is a first-party fire case. And the cases that have been cited here, I'm sorry.
About the report that talk about the vapors accelerated the fire or made it difficult to put out, and therefore it is the proximate cause of the extent of the damage. It may not be an issue about what ignited, but isn't there a factual question as to what accelerated the damages? And she said vapors.
Your Honor, she just, the point of that is not what efficient proximate cause is. It would make a pollution case and fire case is very difficult to discern. The efficient proximate cause analysis is used as a tool in a first-party fire case.
No, it wouldn't. For example, if you were prohibited under the contract to have some pollutant stored on premises, and a fire started, and it found that yes, the fire is normal negligence and would ordinarily be covered, but it's evidence that when the fire spread, it went to the area, to the pollutants that weren't supposed to be there, and it caused problems and it causes explosion. You were saying that just because it's undisputed that it's a covered act that caused the ignition, then we don't have to worry about proximate cause as to the extent of the damages?
Absolutely, Your Honor. And I say this with this notion that when you look at the case law that defines efficient proximate cause, there may be occasions where there are other perils that could be excluded. But if the but for peril, which set everything in motion, is unbroken, and that leads to other losses. West Virginia law, settled West Virginia law provides that coverage should be afforded. And let me say this, Your Honor, with respect, and I'm going beyond my time, that's all right. But with respect to a first party fire case, there are no cases that have been cited that exclude coverage like we have here. None of those do. In fact, some of the cases that are cited, they're talking about either pollution cleanup, which is not what we're talking about, or they're talking about third-party liability claims, which we're not talking about. In other words, we're not talking about the fire happens, Your Honor. It infects the integrity of one of the barrels. Later on, there's seepage of that barrel, and this liquids get into the ground, and they migrate over to someone in Maryland, and the person is upset with their well water or something like that, and they bring a claim. They bring a pollution claim. There are specific rules that apply to pollution cases, but this is a first-party fire case, and that's how the efficient proximate cost works. In the Matthews case, Your Honor, that case, the actual damages that were caused in that case was the demolition team. They actually leveled the dwelling, but our Supreme Court said the efficient proximate cause was actually the imposter that didn't cause any tangible damage. But the court said that was the cause that set it all in motion. And that's what is meant by the most efficient proximate cause. And that's how this court, and that's how the district court was able to discern and say, this is a fire case for which you had agreed to provide coverage for a fire, which is the #1 peril of this manufacturer and of this industry. And you knew about these solvents, by the way, that they were going to use in this process, and you bound the policy and tipped the $80,000 premium. If you put this case in context, Your Honor, this court, you should affirm the district court. He did get it right and find that there is coverage, that is, as a matter of law, there should be coverage, and that the pollution exclusion does not apply in this instance. And therefore, we are entitled to move forward with the second part of the case. Thank you, Your Honor.
Thank you so much. Counsel, you have some time reserved.
Thank you, Your Honor. Let me first emphasize why the estoppel issue is indeed a question of fact. From Joint Appendix 1534, Emily Meyer is explaining her understanding, and she says, from my understanding of the application, sprinkler systems were being installed. They were close. Sounds like they were close to being done. When I quote something, I'm sending out a document saying these are the terms and conditions that you have to agree to. The quote, I indicated that sprinklers were in place. The broker, agent, and insured have to review that and then bind to that coverage. And there's a lot of testimony, that's just one highlight, where Kinsale expressed their understanding that, as pointed out, the concept of being installed is not some indefinite outlier that could go on indefinitely. At the end of the day, it's a question of fact. And I think what we have to look back to is how at the time of the fire, which wasn't until weeks and weeks later, Robert Copley admitted at Joint Appendix 564, we can agree that you did not have an operating sprinkler system prior to using acetone and methanol for testing purposes. Answer, yes. And at page 636 of the Joint Appendix, and the drawings had not been approved by the state, correct? Answer, correct. So this isn't even a case where the sprinkler system was about to be done and there was just one final hose that had to be connected. The plans for the sprinkler had not even been submitted for approval until after the fire. That absolutely creates a question of fact. So in terms of what the parties understood, it is a matter for a jury to evaluate. And I will go back just momentarily to this issue of seeping, Your Honor, because I did look it up, and seeping is to leak slowly. And here, I think it's very clear that the vapors did in fact leak slowly out of these canisters. And Judge Gregory, as you discussed with my opposing counsel, there is evidence in this record to demonstrate that it was the vapors that ignited, and that is what perpetuated the fire that resulted in the loss. And so ultimately, if we look at Murray, the question of what is the efficient proximate cause, what is the predominating cause of the loss, it ultimately goes back to a question for the jury to evaluate. Now, counsel said some disparaging, said some things that weren't about Allison Brenneman and criticized our expert, but I don't believe that there's any reference in the answer brief challenging Ms. Brenneman's declaration, and Ms. Brenneman's declaration in the record averred that but for the vapors, this fire would have been contained to the table where it started. So if this is a matter of what is a predominant cause, is it the small fire that could have been contained on the table, or was it the vapors that caused the fire to extend throughout this facility and could not be extinguished? At a minimum, I would respectfully submit is a question for the jury. We did cite multiple cases, where pollution exclusions have been applied in similar circumstances. We cited Hilland Partners versus National Union out of the 8th Circuit, where a flammable and explosive hydrocarbon condensate overflowed, caused an explosion, and because that is a flammable, volatile, and explosive chemical, the pollution exclusion applied to preclude coverage. Similarly, in Noble Energy versus Bituminous Casualty Company, the 5th Circuit applied a pollution exclusion to preclude coverage when combustible vapors in a diesel engine exploded and said, quote, it indisputably met the policy's definition of pollutant, and the explosion indisputably arose out of the discharge, dispersal, release, or escape of such vapors, unquote. So we have authority that explicitly addresses this very issue, Your Honors. I appreciate the extra time that the court has provided. And finally, Judge King, I don't want to leave your question unanswered. I would ask the court go back, if it may, and review the district judge's detailed explanation as to why he believed 54B certification was appropriate. He explained it in very clear detail, and I would ask that the court maintain jurisdiction over this case and reverse and remand for a trial on the merits of these issues. Thank you again for your time.
Thank you, counsel, and thank you both for your arguments. We can't come down and greet you as we would like to, but know very much that we appreciate you being here and helping us with the case. And wish you well and be safe. Thank you so much.
Thank you, Your Honor. Bye-bye.
Thank you.
Thank you.
I'll ask the deputy clerk to adjourn the court for the morning session.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.